Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1120 et al. State of West Virginia et al. Petitioners versus Environmental Protection Agency and Michael S. Reagan, Administrator, United States Environmental Protection Agency.
Good morning, counsel. Mr. Keller, please proceed when you're ready.
Good morning. Thank you, Chief Judge Srinivasan. May it please the court. Scott Keller for Petitioners challenging EPA's 90% carbon capture, transportation, and storage system, reserving 5 minutes for rebuttal. EPA cannot name a single facility that has ever accomplished this rule's mandate of a system of facility-wide annual 90% carbon capture. To be clear, petitioners want carbon capture to work, and we're at the forefront of trying to demonstrate it at large scale. For example, Minn Kota's planned Project Tundra would be the world's largest CCS project, but even Tundra would not comply with this rule. In fact, the only facility to ever attempt what this rule mandates is Boundary Dam, and it got 89.7% capture for just 3 days, nearly a decade ago, before technical difficulties forced it to scale back to capturing only 65 to 70% of emissions, and from that, just a partial emissions stream. So EPA's selected facility-wide annual 90% CCS system has not been adequately demonstrated, to quote the text of the Clean Air Act, is both a matter of statutory text as well as the record of CCS performance. And this rule's emissions limits, too, are not achievable, again, to quote the Clean Air Act. The 90% CCS system requires more than just carbon capture. It also requires carbon transportation and storage. So EPA is mandating a massive infrastructure build-out of new CO2 pipelines and storage sites, all controlled by third parties, not the power plants. This will entail extraordinary permitting and siting issues in the country. We'll need over 10 times more CO2 pipelines and storage capacity. So ultimately here, EPA is asserting a transformative power over the nation's energy grid by mandating a 90% CCS system that no power plant has done before. That violates the Clean Air Act.
So I take it there's some percentage at which you'd be okay if it was south of 90%?
We would not concede that there is at this point some facility-wide full stream demonstration of CCS. And I think Project Tundra is a case in point. I mean, Project Tundra is receiving federal funds right now on the basis that this is not demonstrated technology. This is emerging technology. And so in thinking about what does it mean for something to have been adequately demonstrated, we would submit that it's what the West Virginia versus EPA dissenting opinion said, or what EPA told this court in 2016 in the Clean Power Plant argument. There needs to be a proven track record. It needs to be something that's already in place and successful within an industry. Here, EPA has cited a few examples, none of which are—
So there's no percentage then for CCS?
At this point, we concede that carbon capture technology exists, but that's very different than, is there a system of emission reduction that can create an emissions limit that's achievable? So for purposes of the Clean Air Act text, well, we of course concede carbon capture technology does exist, but that's a different inquiry. And I think this is one of the key points that we have a fundamental disagreement with how to interpret the statute with EPA, and that's a legal question.
So on the legal question, it seems today you're saying that to be adequately demonstrated, there would have to be a plant out there in the world that has already voluntarily done in every respect what EPA is going to mandate. Is that fair, or am I overreading what you're claiming?
No, Judge Garcia, I do agree. There has to be someone that has done this before. And you know, when we talk about voluntary.
So I suppose the question is, how do you reconcile that with language from our cases like Essex, which seems to say that that's not required? You don't need a plant that's performed in all capacities in exactly the way EPA is going to require. And instead, EPA is allowed to extrapolate from, it certainly can't, make things up or count on new technology, but it can extrapolate from demonstrations, perhaps on a smaller scale.
Well, 2 points, Judge Garcia. I think the first one is even under Essex, that upheld a system for new sources when the system was demonstrated at existing sources. There, this is at 486 F second at 436 to 37. The existing source had met the standard multiple times. It had nearly met it 19 times. So this wasn't a situation where the system had just never been done before anywhere. And then also this court's cases subsequent to Essex said that the idea that, well, something doesn't have to be in routine use. Sure. But what National Lime said and what Sierra Club said is you have to look at, is this achievable under most adverse conditions? And there's a wide gulf between something being in routine use. That's not our argument today. That's never been our argument. But what we're saying is at minimum, there has to be someone that has done this before. And, we could talk about whatever gray areas in between, but I would submit that with this rule and on this record, we're nowhere close to whatever that gray area would be.
I think the question would be, I don't want to cut you off.
Well, I was just going to ask a record sort of specific question. So it's about the Petronova plant. So I think it's on JA 53, EPA. This is a very large slipstream on which they have performed 90% carbon capture. And the distinction, at least in the briefs that the petitioners posit, is, well, that's a slipstream, not the full exhaust stream. And there's a finding from EPA that the properties, the composition, et cetera, of that very large slipstream are comparable to what a full exhaust stream would be at a comparably sized plant. And so as a matter of the record, it seems to me the key question is, do you have affirmative evidence that that slipstream demonstration is not representative of what would work on a full exhaust stream? And I want to know what your best evidence is for that.
Sure, a few responses. First of all, Petronova was offline for more than a third of the time when it was operating. That's a JA 2716. Additionally,
I believe more recently it's been down to 10% of the time that plant has not been operating.
yeah, and look, some of this is also, we're dealing with emerging technology. And so in talking about, what is the state of play today versus the record as of when this rule was promulgated was that. But even beyond that, Boundary Dam is their best example. Boundary Dam was trying to be a full stream CCS system.
I'm sorry, could I just be, I think I might have asked a convoluted question. If I think, certainly one of the important questions is, are the properties of a full exhaust stream materially different from a slipstream? EPA says no.
We say yes.
And what is the basis for that?
The basis is a slipstream has dynamic amounts of pressure. A full stream has dynamic amounts of pressure. A slipstream, it's fixed, it's constant. And that matters because it's much harder to do CCS when you are talking about dynamic pressures instead of just knowing a constant of what's being done. I think Boundary Dam is case in point. Boundary Dam was trying to be full stream. It could never do that. It didn't achieve that. And for record sites on dynamic versus static and full stream versus slipstream, I would cite the court to JA 2796 and JA 2848. And also too, if it really—
Yes, before you go on that, when you say dynamic versus fixed, is that true no matter the breadth of the slipstream? There's just a categorical difference between slipstream and non-slipstream?
Yes, because when you're talking about dealing with the full set of emissions and you're talking about trying to get the demand needed to the electricity grid, you're never going to know completely exactly what demand is needed. And so when you're talking about all of the emissions, that's different than controlling for a partial set of the emissions. But also too, I would submit that if EPA were right, that it's just so easy to scale up from a slipstream to a full stream, then why has nobody done it? And I think Boundary Dam really is case in point here.
Well, their answer to that is that no one is going to employ this very expensive technology unless it's required by regulation.
And I don't think that's right. Part of the thing about the congressional subsidies and the federal funding and state grants for these programs are so that we can demonstrate this. In Project Tundra, that is planned to be the world's largest CCS project, that's been in planning stages for 10 years, and this rule is threatening its viability. That's an example where this project was being planned, and it was being planned without governmental mandates. And again, if the record in the state of technology in the world were different, that someone had done this, maybe EPA would have a much stronger basis to come into court to say that this has been adequately demonstrated. Again, we want CCS to work.
Mr. Keller, if you could speak to, I agree that this is a really important question, right? Can you take the evidence from slipstreams and extrapolate them to a full stream? And one of the things that EPA says is that the fluctuations and variability in the full stream are not meaningfully different from the slipstream. And then they cite to, variability about turn down rates. But turn down rates don't seem to me to be quite the same thing as the type of fluctuations that petitioners are talking about. So I'm wondering if you can speak to that question, right? Does the variability and how, how it deals with turn down rates, how do we think about that in this context?
Yeah, I think all of this goes to, it's similar, but it's not identical. And it's similar in that when a power plant thinks about just generating power, that is one question. But how it transmits power onto the electricity grid so that everyone can get the power they need. And this goes to our point about EPA didn't even study operational reliability. They only studied resource adequacy. That's a very similar point. And that the real world of trying to generate enough power and get that power out to where it needs to go is going to have to take into account all sorts of factors. Is there a winter storm? How do we get it from one part of the country to another? If you can't, then you have to take account of regional considerations, and that wasn't done here either. So, I think in some ways, though, to back up to the statutory text, it's not our job to come in here and to say that here is the definitive explanation about slipstreams and full streams. EPA has to be able to demonstrate that its facility-wide annual 90% CCS system has been done somewhere, that they want to run away from that rule. But that's the rule they selected. And so to say that we're coming into court purportedly adding statutory terms is just not correct. That's the rule they selected. In fact, I would cite this court to JA 90 and JA 146. This is the rule that EPA promulgated. They said that partial capture
And it seems to me that the achievable part of 7411 is tied to when the rule would go into effect.
Judge Rao, I think that achievable, though, still has to be looking at what is available for installation today, what would be representative of the industry as a whole.
If the technology were adequately demonstrated today, assuming that, if it were adequately demonstrated today, then it seems a different question whether it would be achievable to have widespread industry-wide use under the most adverse conditions, the national Lyme test. But that is a future inquiry. That is an inquiry that it does seem can be future looking. Petitioners disagree with that?
I think this comes back to in looking at this court's cases on what minor extrapolations and projections are allowed. The court's never had a case where we're talking about a projection of something 8 years into the future. And I think this gets at the core of this case of why, no one's been able to do it. But and to be very clear, the industry has wanted CCS to work. They've spent 2 decades and billions of dollars trying to demonstrate this at large scale. And then EPA comes in with a rule and says, 8 years from now is exactly when you'll all be able to do this.
But what is the answer to the question on if the statute says achievable and then it raises the question achievable by when? And is your response that when the statute says achievable, it means achievable by now, or is it that it means achievable by the effective date?
Our position is achievable by now, but even if you disagree with that, I don't think this is even achievable in 2032 when they say it would come online.
That is a separate question from the legal question.
Make sure there's no additional questions for now.
I have another question. Yeah. So here EPA relies heavily on what it says it's collective judgment. They have different examples, with respect to the arbitrary and capricious challenge. And petitioners have a series of arguments about ways in which this rule is unreasonable or, doesn't hold up. And, if we agree with petitioners on some of those arguments, but not others, how do we think about the agency's collective judgment in enacting this rule, right? So do petitioners have to kind of run the board on these questions in order for the rule to go down?
No, I don't think so. To take the State Farm test of arbitrary and capriciousness, if EPA has not considered an important part of the problem, that's a basis to vacate the rule. I mean, here, not studying operational reliability or not modeling operational reliability, I think is a great example of a classic State Farm error. It's not enough to look at just resource generation. You have to look at, is the power going to be able to be transmitted properly? That's operational reliability. And if I could point the court to JA 3541 to 42, these are America's Powers comments. They actually submitted a study, a study from Quanta saying that this is how the type of operational reliability study could have been done. And EPA concedes that they just didn't do this. This is their response brief at 95. I think that, Judge Rao, is an example of that's just an error that would completely vacate the whole rule. We don't have to run the table on all of the other ways in which this rule is arbitrary or capricious.
Okay, thank you, Mr. Keller.
Thank you,
We'll
Your
leave you some
Honor.
time for rebuttal. Ms. Coleman.
Morning, Your Honor. May it please the court, my name is Chloe Coleman on behalf of the United States Environmental Protection Agency. With me at counsel's table are my co-counsel Eric Hostetler, Howard Hoffman from the EPA Office of General Counsel, and counsel for respondent state interveners, Michael Myers. I will be addressing EPA's determinations that 90% CCS is adequately demonstrated and that the resulting standard for certain coal and gas plants is achievable. Mr. Hostetler will be addressing EPA's determinations concerning CCS cost and reliability. With respect to whether 90% CCS is an adequately demonstrated system of emission reduction, petitioner's challenge comes down to a dispute over the factual evidence and whether the record here is sufficient to support the agency's determination as to 90% CCS. A review of the record shows that EPA acted reasonably. It relied on extensive direct and corroborating evidence to draw a conclusion in its expert capacity that this system of emission reduction has been already demonstrated.
Ms. Coleman, before you characterize this as just a factual question, What about the fact that EPA here in the rule adopted a very forward-looking understanding of what has been adequately demonstrated means? I understand that the agency is disavowing that interpretation of the statute now, but if this court were to think that atextual and perhaps ungrammatical understanding of has been adequately demonstrated is incorrect, does that mean the rule fails?
Well, Your Honor, to be clear, the agency isn't disavowing anything. What the agency was doing was summarizing. No, Your Honor, that's what this court's precedent says. The rule and the many places that my opposing counsel quote this rule are just representative of what this what this court found in Sierra Club, in Essex, in Portland Cement, in these other cases. And EPA accurately reflected.
Where do those cases say that has been adequately demonstrated means it can be demonstrated in the future?
Well, Your Honor, we think those courts left open the possibility that EPA might, in fact, be able to provide an adequate evidentiary demonstration to support a forward-looking projection. We are not suggesting that that's what happened here. And so we don't think this court needs to get into those issues. It's simply not presented.
But if we disagree, I mean, that is the approach, that is the legal interpretation that the agency offered for its rule.
Well, Your Honor, we fall so well within those boundaries that I think it's, ultimately not a consideration here, whether or not there is a circumstance in which the agency might theoretically be able to justify a more progressive rule. We just don't think you need to write an opinion that reflects anything about whether this court's previous precedents in that respect.
My question. My question is, if the agency's legal theory in the rule is something that we find to be unlawful, then does that just jeopardize the rule altogether? No,
Your Honor, it doesn't. I mean, we think we win this case. We think we win this case under petitioner's interpretation, even if something like has been adequately demonstrated. We don't actually disagree with petitioners about the dictionary definition of those terms.
And the fact that that's not the reasoning that the agency relied on?
We think that is the agency's reasoning here. That, the court, or rather the agency at several points in the rule explicitly says it's not relying on the outer bounds of its authority. That's in the rule at 39.830 and 39.832, 39.888, 39.813. These are all places.
Lots of places where the EPA in the rule takes a forward-looking interpretation of has been adequately demonstrated.
Well, Your Honor, as I suggested, I think that's the EPA attempting to encapsulate what it understood this court to have said in the previous cases. There will certainly, be an opportunity should another case come along where EPA tries to rely on that outer limits for this court to assess its prior precedents and decide whether those were reasonably decided. But we don't think that's necessary here. It's simply, the case that 90% CCS is a system that already exists. It's already doing the thing that we say it needs to do here. So the question of whether or not, EPA could substantiate through sufficient evidence that some kinds of forward-looking projections can be considered adequately demonstrated, we just don't think is an issue here.
So you want the court to uphold the rule on a legal theory that the agency didn't rely on?
Well, we want this court to uphold this on sort of being well within the bounds of any potential reading of the statute. We think any reading of the statute is sufficient to allow us to set this rule because we have an evidentiary foundation here that is more substantial than what was decided in Essex or Sierra Club or any of these other cases. And so even if the interpretation in those particular cases is narrower than what the agency may have tried to paraphrase in its rule, we think we're well within the bounds of those cases. And that's because CCS here is a system that is already in operation on large exhaust streams at commercial scale facilities. We're not talking about, the kinds of things that were in Essex and Sierra Club were sort of individual test data points. They weren't looking at continuous capture of a pollutant. They weren't looking certainly at annualized performance the way our opposing counsel has suggested. And so when we're talking about kind of what the agency did here, we're talking about looking at facilities like Boundary Dam, like Petronova, that operated for years and consistently achieved 90% capture. Petitioners really, only objection here is on this slipstream issue and whether or not 90% capture on sort of a slipstream is the same thing as full exhaust. That's really, I think, as your honors have identified, where this case turns. And I think it might be helpful to note sort of from the beginning what a slipstream is.
I think they also have a time dimension. I definitely want to hear the slipstream part of it, obviously, because that's so much at the heart of this. But I think they also have a time dimension, which is so you can do something for 3 days and on a smaller stream. That's still not enough.
Well, Your Honor, I don't think this court needs to decide based on the 90% 3-day demonstration at Boundary Dam. We think the annualized performance that's been happening on these slipstreams is more than adequate, whether or not you think that 3-day performance would be enough test data. And that's because a slipstream is fundamentally, when you're thinking about exhaust coming out of a plant, we're talking about a big duct with air rushing through it. And some of that air is going to the right and some of that air is being routed to the left. And fundamentally, that's all a slipstream is. It's a portion of the exhaust that is being routed towards CCS instead of towards a stacked. It does not have different properties. It's the same gas. There's no difference in pressure. There's no difference in temperature. It's subject to the same variable flow potentially that the whole stream is. And that's what EPA found in the record. It said, we looked at Petronova's slipstream, which is the size of a 240 megawatt equivalent facility. That's larger than 41% of the regulated facilities in this rule. And it said,
EPA has not answered the question. I mean, the petitioners have raised a number of ways in which a slipstream is fundamentally different. It operates in a different way and keeps things in a steady state, different from a full stream. And in response, EPA says, well, some of the slipstreams are very large, but that doesn't answer the question about whether a slipstream is fundamentally different from a full stream.
Your Honor, I agree that size would not answer that question alone. However, I would encourage you to look at the citations petitioners actually cite for the suggestion that slipstreams are steady state. The actual things they cite do not support that proposition. They are evidence that concerns something called turndowns. They cite us with respect to turndowns, which is what happens when a coal plant isn't operating at its full capacity. It might be operating at a lower capacity. And in fact, EPA's analysis showed that even under turndown conditions, CCS operates just fine.
Turndown conditions are not the same as the variability.
We agree, Your
between
Honor.
a full stream and a
We
slipstream.
absolutely agree, which is why it's strange that that's a citation that petitioners were citing for the suggestion that slipstreams are steady state. None of the two comments they cite, neither one from EERC or from Chikanowicz, say anything about steady state conditions. They don't say anything about pressure. They don't say anything about temperature. They don't say anything about variability. The first, EERC, is merely a restatement of a list of slipstream facilities.
So then why does EPA have no evidence of a full stream 90% continuous carbon capture?
Well, Your Honor, we think that's very simple, which is that in the absence of a regulatory signal or an economic signal, there's no reason that these facilities would be investing in full-scale carbon capture.
Even the projects, under the Energy Policy Act or Boundary Dam, none of them have shown this. They can only show 90% rates of carbon capture on slipstreams.
Well, they have only done that. That doesn't mean they couldn't do it on a full exhaust.
But
And we think,
okay, then how has that been adequately demonstrated?
well, Your Honor, because I think in the first instance, there are two questions, and I think Judge Srinivasan summarized these. One is, do we have information as to why a plant might not be operating this on full scale? We think that's very obvious. This is an expensive technology, and it's one that you wouldn't build at full scale if you didn't have a reason to do it. The facilities that are building these systems now and are doing so on slipstreams are doing that because they might have a contract to sell their carbon dioxide to an enhanced oil recovery, operation, and they don't need to capture 100% of their CO2 to do that. Or they might be doing it for purposes of demonstration. And the
What's the answer about Boundary Dam then? Because they certainly very much wanted and tried to do this, and then they couldn't. But they could do it on a slipstream.
yes.
So viewed from petitioner's perspective, that is, maybe we don't know the reason, but it certainly seems to strongly suggest there is something different and easier about doing this on a slipstream where it worked than on the full exhaust stream where it didn't.
Well, Your Honor, I'm glad you raised that because I do think we have an answer as to Boundary Dam. This is a facility, again, that does not have a regulatory or a financial incentive at this point to optimize its facility to 100% capture. That doesn't mean it doesn't know how. And we know that it knows how because these same operators put together the Shand feasibility study for another one of their units that's 3 times as big, showing exactly what they would do in that facility to solve all of the problems at Boundary Dam. One of the major problems at Boundary Dam is it's using a kind of sulfur dioxide system, that is upstream of the CO2. And what we mean by that is first this exhaust goes through PM controls, goes through NOx controls, it goes through sulfur dioxide controls, and then it gets to the carbon dioxide scrubber. And it needs those sort of earlier steps in the process to do their job, because otherwise you get gunk, essentially, in the carbon dioxide scrubber. So what happened at Boundary Dam is that they've run into significant issues with the upstream performance of their other technological systems. And we have evidence, and that evidence is Petronova, that those kinds of problems will not repeat in the kinds of configurations that are used in the
I
United States.
appreciate that point, but if the properties of a slipstream are otherwise all the same, then why didn't Boundary Dam have the exact same problem when it tried to do this on a?
That, Your Honor, is because the sort of one of the great values of a slipstream, if you're not in a circumstance where you're under an environmental obligation, is that you can continue to run your plant while you're doing maintenance on your carbon dioxide system. So in a case like Boundary Dam, there's not a lot of incentive for them to turn off their whole facility, to run at 100%, do all of the optimization, spend all of the money on the potential retrofits to get this up to 100%, and then have to sort of, do all of that expense and do all of that maintenance work if they don't need to, right? If you were building a facility with no environmental regulation, you would presumably build a bypass the way Boundary Dam is essentially operating. And you would do that because that way, if you want to keep operating your plant while you do maintenance on the carbon dioxide system, you can. Or, for example, I think one of the things that's notable at Boundary Dam and worth keeping in mind is there are solutions you may know that will work, but that you may not spend the money on. So for example, if the solution to your problem is that you need to do more maintenance more often to resolve the problem of, additional fouling pollutants getting into your carbon dioxide systems, one of the ways you can solve that is through a redundancy. So instead of just having one pipeline that, connects point A to point B, you build two. And that way you can take the first example offline while you're running the second one and vice versa. And that allows you to be doing maintenance without taking the system down. But you wouldn't spend that money to do that kind of redundancy unless you needed to. And so in this case, Boundary Dam.
That might be quite reasonable, but that's not what the statute says. It says has been adequately demonstrated. And all the verbs you use are this will happen, this could happen, this, they might do this. I mean, those are all forward-looking understandings of what a plant might do, but that's not the EPA's obligation under the Clean Air Act.
Well, Your Honor, EPA's obligation is to come up with an evidentiary defense here that asks these questions and has answers for them. And we think it does. So in the first instance, Boundary Dam has, in fact, solved many of these problems. It's operating with high levels of it's achieving this 90% consistently. In the third quarter of 2023, which is the last on record, it was online 98%
consistently from the slipstream.
They have chosen to operate on a slipstream. That's correct. But let me answer your question, which is, even if you assume that the kinds of solutions at Boundary Dam have not been fully applied, and that's why Boundary Dam is not sort of going ahead with 90% capture on the full stream, we have additional facilities that have done this successfully. Petronova is more than twice as big. It has a more successful wet FJD scrubber, which is what you use in the United States generally for sulfur controls. It has not seen the kinds of technical issues.
Petronova is also a slipstream.
It is a slipstream facility,
Right,
but
so 90% of, I think, 30%, 37% of the flue gas, that's running on a slipstream again.
Well, Your Honor, I think these are two distinct questions. One is, are there technical issues that prevent adequate performance of this system? We think Boundary Dam has run into some of those issues, but we can see in a facility like Petronova that those issues don't recur. Petronova has been very successful at running this technology.
On a slipstream.
On a slipstream. But again, that's the the technical issue. And then there's the question of, are slipstreams representative? And do we have a good explanation for why people are not building 100% full exhaust systems? And we think we have adequate answers to both of those questions, because on the one hand, there isn't a regulatory or financial incentive to build a full exhaust stream capture system. So a plant like Petronova simply didn't need to do that. It had no reason to do that. And we have answers to the questions of whether or not a slipstream is a representative waste stream of the exhaust. Again, petitioners do not substantiate their suggestion that slipstreams are steady state or that they have different properties. None of their citations actually use those words. They don't talk about pressure. They don't talk about steady state.
Burden to show that it has been adequately demonstrated. So EPA's assertions about that don't necessarily answer the questions that petitioners have raised, I think.
Well, Your Honor, we made a finding in this record that Petronova's slipstream had the same properties as its full exhaust stream. That's in the record. And so to the extent petitioners are going to say they disagree with that, they need to be able to present some evidence to the contrary, and they haven't done that. Part of the reason that the slipstream is not discussed in greater detail in this record is because it is a fundamentally logical and basic assumption within the industry. We do demonstration projects on slipstreams because they are representative of the exhaust conditions at a full stream facility. And so the suggestion that petitioners are making is a fairly counterintuitive one, that the gas that's sort of going to the right instead of going to the left is different in some way. If they're going to try and substantiate that that's true, we agree we have the burden on adequate demonstration, but we've made the requisite findings on a slipstream. And if they want to dispute those.
It seems to me like so much turns on this, whether the slipstream is representative enough that you can do a full stream. It seems like it would be analogous to saying, all right, we've demonstrated that this happens on a Monday. And then the EPA says, well, then why wouldn't it happen on Tuesday? I mean, what's the difference? It's just a day of the week. That's a random thing. But then if somebody comes in and says, oh, well, actually, if you look at commute conditions, they're actually different between Mondays and Tuesdays. And then it starts to look like, well, actually the day of the week can kind of matter. And that's where we are on this, isn't it? That
I suppose, Your Honor, but in this circumstance, they said, well, commute conditions are different on a Tuesday. And we said, there's no evidence that that's true. And they marshaled no evidence to show that it was true. When we're talking about whether or not this slipstream performance is the same as full exhaust performance, which again is petitioner's only objection in many cases to the record evidence here. So I agree this is a central issue. If they're going to say that we are wrong about this, they have to have something to rely on to say we're wrong about this. And I would encourage you to look at those comments because none of them are making the assertions petitioners say they are.
So from your perspective, EPA is already, regardless of whether it was anticipatory, you think there's enough in the record right now to show that EPA already thought about the question of whether there's a difference between dynamic and fixed and has made a finding based on its own assessment that there is no difference between those and that the physical conditions of the stream don't vary based on whether it's a slipstream or full stream.
That's correct, Your Honor. At 39,850, we state that the slipstream properties at Petra Nova were identical to its existing exhaust facilities. I would also encourage you to look at JA 780, which is a diagram from the Shan study, just showing what these ducts look like. So you can really see they're just sort of branching out from each other, and they essentially have gates that open and close to let air through. And then the EPA did separately consider things like what happens when you have a variable amount of exhaust coming through the facility. That analysis is also in the record. It's at 39,853 to 54 for coal plants. It's at 39,929 for gas plants.
That variability is not the variability that petitioners have cited to as the difference between full stream and slipstreams.
No, but it is the variability.
It's different.
It is.
You can use the same words, but they're.
No, Your Honor, I agree that
things.
I agree that it's different, but it is the kind of variability that their own citations are talking about. So to the extent that their citations are not supporting that slipstreams.
What about the AEP comments, that are at JA 3251 about how chemical plants work and how, integrating these things into a plant has not been adequately demonstrated?
Well, Your Honor,
EPA's response to those?
We disagree. We think there is substantial evidence in this record concerning power plants specifically and the kinds of systems they're going to be applying here. And again.
Well, you just said there were no comments or no evidence. I mean, I think that there are comments and evidence.
Well, I don't think those pertain to slipstreams specifically, and there being differences in the properties, right? I mean, to the extent that there are allegations in this record that slipstream facilities are not sufficient, but they don't say why. And they don't say, we think slipstreams have different properties, here's how we know. And so to the extent that the expert agency, which is due deference, has made determinations on the record with respect to these specific slipstreams at facilities like Petra Nova, at facilities like Boundary Dam, where in fact that slipstream is often up to 85% of the full exhaust. So it's really not sort of like a tiny little portion that would be different. It's the big kahuna.
But it's not the amount. It's, that's not what petitioners are saying. They're not saying you can't do it on a big slipstream. It's not the size of the slipstream. It's the fact that a slipstream operates in a different manner from the full stream.
And if they had established that it does operate in a different manner, I would agree with you, Your Honor, but they have
also,
not.
You're not just talking about as I understand it, you're not just talking about the amount. You're not saying, look at the size of this slipstream. Even if it was a 10% slipstream, it could be a gargantuan one relative to other things. You're talking about the ratio.
Yes, but I think, to the extent that we're trying to address an important question here. I think it's reasonable to look at, do we have examples that are high percentages? Do we
Right,
have
that's the
examples that are
ratio.
high volumes? And we have both.
Mhm.
In this case, Petronova is a high volume slipstream. It is taking an amount of exhaust. It is successfully running a 90% CCS system. In fact, it's consistently getting 92.4%. And it's doing that at a size that is comparable to 41% of the regulated units in this rule. So we have it in volume and we have it in percentage, where Boundary Dam is doing up to 85% of its exhaust stream, and in some
Of a
cases has exceeded
slipstream
that.
at
Once again,
Petronova.
Your Honor, I acknowledge that. But I think if Your Honors are going to sort of look into this question of whether or not there is evidence that a slipstream is the same or different, EPA has determined that it's the same. Its evidence is in the record. Petitioners say it's different. They have no evidence for that proposition.
They cite these two comments, and you were agreeing with Judge Rao that in some respect, these comments suggest there's more variability. Or what is the variability?
Sure, I'm happy to
that
explain.
These comments reflect.
So the first set of comments, the EERC comments, simply identify a list of facilities that are using slipstreams. And they sort of conclusorily say, those must not be adequate demonstration here. They give no explanation. They give no evidence that that's true. So we think you can discount that entirely. What the Chikanowicz comment says, the second one they cite, is essentially that because a slipstream is not, because there's a way to bypass the slipstream systems in and of themselves don't answer the question about reliability. This is different than the properties of the slipstream. But the point in that comment is, if you can continue to run your coal plant without turning off, because you can still go around the CCS system when the CCS system has a problem, that doesn't necessarily tell you that a full exhaust stream will be able to operate all the time. That's a separate issue. It's an issue of availability. Are these CCS plants operating enough of the time that they can allow these underlying generation units to continue to be available to the grid? So that's what the Chikanowicz comment is talking about.
To the extent that
It's not a
petitioners-
slipstream issue.
Right. Petitioners are saying in a slipstream, this comment shows that in a slipstream, the variability of the amount of flue gas going through is more controlled. Your response is, this doesn't say that.
It doesn't say that. It asks a question which says, we don't know, based on slipstreams alone, whether there would be a reliability problem because they aren't operating all the time. These facilities can bypass them. But EPA separately analyzed availability, and Petronova was available 90% of the time it operated. That's consistent with other industrial processes. And I think it's important to note that 10% when there's an outage at your CCS facility is not additive to the other kinds of outages. Essentially, you align your maintenance so that when your sulfur dioxide scrubber needs maintenance, when your underlying generating unit needs maintenance, you do that all at the same time. So that 10% of the time that CCS needs maintenance is entirely consistent with other processes like that, with other scrubbers like the sulfur dioxide
How does the
system.
math work out? So if these, even on a slipstream, if we assume that's analogous, is getting 90%, but there's 10% unavailability over the course of a year, that's only 80%.
Well, no, Your Honor. So compliance in this circumstance is judged by when the plant is operating. So you're not dinged for not running your CCS if your plant's not making power. Ultimately,
Don't these plants have to achieve 90% emissions reduction annually?
yes, Your
And
Honor.
how can they do that if 90% is the most of carbon capture is available, and that's only available 90% of the time?
Because the plant isn't running the other 10% of the time. Sulfur dioxide scrubbers, which are already on these facilities, also have the same thing. They are running a 90% capture system. They are also unavailable part of the year because of maintenance. But because the generating unit itself needs maintenance. So when you take the facility offline, which is something these facilities do in the normal course, you do your maintenance on your sulfur dioxide scrubber, you do your maintenance on your carbon dioxide scrubber. And so that 10% of the year is already built into
So
the.
if the plant's only running 1 out of 365 days, but it achieves 90% on that day, the criteria is satisfied.
Yes, it would comply with this rule. That compliance is only measured when the facility is running. So there is no harm, no foul if your facility is offline for maintenance.
Is it fair to say on the slipstream, full stream question, and what I particularly mean by that is on the question of whether there's a difference in the property, that there's the character of the stuff that's going through differs based on whether it's a slipstream or a full stream. Is it fair to say that EPA's position is there's nothing in the record that supports that proposition? That proposition has been asserted, but there's nothing in the record that actually supports that proposition.
That's correct, Your Honor. Not only is there nothing in the record to support any distinction between these kinds of streams, there is evidence in the record that these streams are the same and have the same properties. Your Honors, I want to ensure my co-counsel can answer your questions on cost and reliability. Yes, please.
I have a question about the transport of CO2.
Certainly.
And whether these timelines are achievable. So am I correct that there is no federal scheme for CO2 pipeline permitting, right? There's no federal statute or federal, like those, the permitting for CO2 pipelines would be state by state.
Your Honor, there is a Pipeline and Hazardous Materials Safety Administration that deals with a lot of elements of this, in particular on the sequestration side. But to the extent that you're asking whether
It's
there's
not
sort of
like-
a specialized
Well, there's no
permitting
there's no
process.
there's no national permitting process for CO2 pipelines.
Your Honor, I admit I am not familiar with all of the details of the permitting system
Okay,
here,
I don't believe that there is one, so I was hoping you could confirm that for me.
No,
don't-
I think that's correct. I mean, there are certainly circumstances in which if you are doing interstate pipelines, there may be additional
Well,
considerations.
like FERC has over natural gas pipelines, but I'm not aware that FERC has any authority, for instance, over CO2 pipelines.
No,
Or that
no.
any other agency does. I mean, these timelines for dealing with CO2 pipelines seem very optimistic. I mean, there are a number of states that have said we're not going to have any CO2 pipelines. Invariably, some of these CO2 pipelines are going to have to cross state boundaries, and that's going to require permitting from multiple states. It's going to probably involve litigation in state courts and federal courts. And I'm not sure how EPA has demonstrated that these timelines are achievable for pipeline permitting.
Well, first of all, Your Honor, EPA's analysis here, which used an expert engineering firm, was built on examples of actual pipelines. And so EPA was looking at carbon dioxide permitting that's already happened on pipelines and asking what was achievable in those circumstances. And it's also looking at comparable examples. So in the natural gas context, between 2017 and 2021, an average of 1,000 to 2,500 miles of pipeline were built a year. Under this rule, EPA anticipates that 1,000 miles would be built a year. So that's well within what the natural gas industry is achieving, even with permitting difficulties or litigation. So that's the first thing I would say to Your Honor's question. The second is that in many respects, EPA's analysis was conservative. And so what EPA was doing with respect to these pipelines was asking, is it possible for every single one of these individual units to build their own pipeline directly from the unit to a sequestration source? And EPA said that was the case. And that was conservative in two ways. First, it assumed that every single facility that has not announced a retirement date would in fact be installing CCS. That ignores the medium-term co-firing category. Certainly not all facilities are going to end up building CCS. Some of them are going to be in the medium-term category as well. So this was sort of overestimating in the first instance the number of facilities and therefore the number of pipelines. It was also conservative in a second respect, which is EPA declined to rely on the anticipated build out of what's called a trunk line network. So there are already 5,000 miles of CO2 pipeline in the United States, and some of those include large trunk lines. So there's a trunk line that goes from Colorado through New Mexico to Texas, for example. Those are the kinds of large infrastructure heavy projects that might take longer to permit. But once they exist, it would be very efficient and very easy for these facilities to hook up into them. Now, EPA didn't want to assume that there would have to be a trunk line build out here. That's why it estimated the 5,000 miles of pipeline that it did. But other parts of the government are anticipating this kind of large trunk line build out. So the expectation here is, that ultimately compliance.
Which parts of the federal government, since I don't think the federal government has any authority over CO2 pipelines?
Well, these are other parts. So for example, the Pipeline Safety Administration.
Okay, but I mean, the permitting and the eminent domain and the litigation all may take place at the state level or multiple state levels if there's no federal system to ensure uniformity or, even in systems like natural gas, pipeline permitting. I mean, this court hears every pipeline is challenged, it takes years of litigation. And this is a system where there's not even a national solution for those pipelines.
Well, Your Honor, I think, even if we sort of take away the conservatism I was just discussing and assume that we're really going to have 5,000 miles that are built, the timelines here account for 5.5 years from start to finish on the pipeline system. That's less.
Is that really 5.5 years though? Because the SIPs have to be first approved, right? So doesn't that reduce the amount of time that's left for permitting? I mean, are people going to be building CO2 pipelines before the SIPs are approved?
They won't begin building. The expectation is that the first year of the work on the pipelines in terms of feasibility will be done concurrently with the state plan. The remaining 4.5 years will start after the state plans are done in June 2026. But that still includes a little bit of leeway before we actually get to the compliance deadline. And in addition, the rule accounts for the kinds of sort of, one-off circumstances that might be necessary here if an individual facility runs into a permitting issue. That's what the 1-year compliance timeline extension, for example, can be used for. So if you have done everything you can to get through this permitting process and through no sort of fault of your own, it's still ongoing, that's the circumstance in which the states can grant those kinds of compliance exemptions as well as EPA.
For
And
new
that's
sources, can EPA do anything to go beyond 1 year?
not beyond 1 year, Your Honor, but new sources have the flexibility of where they're siting in the first place. So they can take into account upfront the kind of pipeline challenges they might, encounter and where a pipeline is going to be best sited and where they're going to have the easiest access to sequestration. So in those circumstances, you're more likely to see these facilities siting close to their sequestration location, so they have potentially a short pipeline, and then just running their electricity back to the grid by transmission.
So in response to Judge Rao's question about the SIPs, my understanding was that your position is construction will start once SIPs are submitted, but before they're approved by EPA, right?
That's correct, Your Honor.
Why is that a reasonable approach? What if EPA comes in and requires some major change?
Well, Your Honor, in a circumstance where a state plan reflects the requirements in the rule, there'd be no reason for EPA to deny that plan. And in a circumstance where, for example, the state has provided a longer time frame based on some exigency, right? This is a facility that needs more time to build a pipeline. The timeline pressure is the same, right? They still need to be working as quickly as possible towards getting towards compliance, because even that extended timeline would be the sort of fastest possible timeline they could comply with. So I don't think there's really a circumstance where someone would be sitting on their hands because they thought they got a state plan extension. In any circumstance, they're going to be doing this same work moving forward. If I may, Your Honor, I'd like to conclude with 2 points before I turn over to my co-counsel here. First, EPA's technical record-based determinations that 90% CCS is technologically sound and can be installed by 2032 fall squarely within the administrator's discretion under the Act and the agency's expertise. Those determinations were reasonable and they're due substantial deference. Second, notwithstanding the arguments that you're hearing today and that this court has heard in similar cases, this industry actually has an excellent track record of adopting and running the emission controls that EPA has found demonstrated under this Act. With those thoughts in mind and for the reasons in our brief and respondent interveners' briefs, the petitions should be denied.
Thank you, counsel. Mr. Hostetler.
Good morning. May it please the court, Eric Hostetler, also for EPA. I'm covering 2 discrete issues pertaining to carbon capture. First, EPA's assessment of reliability impacts. Second, EPA's assessment of cost impacts. Since my friend mentioned reliability, I'll start there. EPA did properly assess impacts on grid reliability in this rule. And just a couple of initial points. First, the agency does have considerable experience over decades assessing the effects of its pollution rules on the power sector. So assessing the impact of these particular standards on reliability was an exercise of predictive judgment that was well within the agency's expertise. Second, I did want to flag that petitioners' reliability arguments are in large part just a rehash of their demonstration and achievability arguments. That is, their arguments lean very heavily on the premise that 90% carbon capture is unachievable and can't be achieved by the deadline, and therefore that's why plants will close, which is why there will be a reliability problem. So if you credit our demonstration and achievability arguments, their reliability concerns largely fall away. But to the extent they don't, EPA's judgments are well supported and meet the applicable arbitrary and capricious standard.
Mr. Hostetler, so EPA agrees that grid reliability includes both resource adequacy and reliable operation. Is that correct?
That's correct.
But EPA didn't really consider reliable operation in this rule. So is that in itself arbitrary and capricious? I mean, the agency recognizes what's required for grid reliability, but then didn't study something they said was necessary for grid reliability.
I don't think that's a fully accurate characterization of what's going on here. First of all, we agree that operational reliability is a component of grid reliability, as is resource adequacy. But let me explain why EPA focused its modeling on resource adequacy and also explain why these two concepts overlap to a large degree. So the modeling that focused on resource adequacy was looking at operational reliability concerns to a large degree. In terms of the concepts we're talking about here, resource adequacy is taking a more macro level view, looking at generally whether there are enough generation resources to meet demand. Operational reliability is looking at a more granular level at whether day-to-day operations of the grid can withstand sudden disturbances. And here, EPA focused its modeling on resource adequacy in as much as the additional regulation of coal and gas plants most directly affects the adequacy of resources to meet demand. The rules don't really affect things like, whether transmission lines are being properly maintained. There are a lot of aspects of operational reliability that this rule has nothing to do with. That said, the modeling EPA did of resource adequacy does look at a lot of constraints that bear upon operational reliability, including projecting the need for adequate reserve margins, assessing the seasonal availability of particular types of resources, assessing transmission constraints, assessing the time it takes for sources to ramp up demand.
So you're saying there's some overlap, but so even assuming that the modeling of the resource adequacy is reasonable, I mean, it doesn't seem that EPA has addressed operational reliability.
We disagree. First, EPA didn't stop with the model. It looked at a lot of other evidence and information in the record, including studies that bear on issues of operational reliability. Those studies showed that even in a world where there were fewer fossil generation resources, fewer coal plants, operational reliability can be maintained through a number of strategies, what is referred to as a portfolio approach. So things like improving energy storage, increasing the resilience of the transmission lines, or improving their capacity, looking at distributed energy resources.
But has EPA demonstrated that that will be a reliable, part of grid operation?
Yes, Your Honor. The only thing the integrated planning model didn't do, because it would be impossible to model with certainty, is to take a granular look specifically at which resources would be available to meet minute-by-minute demand everywhere in the country, because that kind of granularity would require a ton of guesswork and wouldn't be a particularly useful exercise for purposes of macro-level decision-making.
The petitioners say that Quanta, a group, was able to do something resembling that type of analysis. Can you just explain your response to that?
Yeah, just to clarify on that Quanta study, that study wasn't assessing this particular rule. It was looking at some earlier year and not this rule. And it was looking only at one region.
Proof of concept, and that you could have done
Right, right. EPA didn't conduct its own operational study along the lines of the Quanta study because it would have been ill-suited to the task at hand. The IPM model is very well suited to looking at resource adequacy and how the power sector will respond to future demand when the rule is implemented that might cause certain generation resources to go offline. That kind of macro level analysis is really the best analytical tool EPA could have had. It's much less useful for macro level decision making to try to model granular location specific operational reliability issues, as those sorts of granular issues, as I said, require a lot of speculation about compliance decisions. And those kind of granular issues also are the kinds of issues that are resolved locally by reliability authorities. They aren't, that's not something you solve at a macro level. So while EPA hypothetically could perhaps have tried to do something like that, the juice would not have been worth the squeeze in terms of the usefulness of the information that could have been obtained.
Okay. And you were also making the point that EPA, even if it didn't conduct that kind of study, relied on more generic studies about how a resource mix change can be dealt with. Do you have record citation for the best places we could look for that?
Yeah, I'm trying to find them here. I think JA 5536 to 5537. JA 5546, JA 6019 to 20 are some locations. There may be more.
661.
It's very strange.
Let me just going back to the IPM model and what that projected. It did include all these operational constraints. They're built into the model, and ultimately that model projected that there would be sufficient resources to meet capacity demands with this rule implemented. The model compared the baseline world without this rule to a world with this rule, and the model does project some incremental coal plant retirements, but those are really incremental and modest in context. We're in a world where the power sector is transitioning to cleaner generation. There are market trends going in that direction. So the retirements we're talking about here are small in number relative to the number of retirements that are predicted in the baseline. But importantly, the model projects that those retirements will be fully offset by more gas, by more renewables, by more energy storage capacity. So bottom line, it does not project any resource deficiency. And
Can I ask a question about your cost argument
sure.
briefly? Are you taking the position that EPA doesn't even have to consider a cost if it won't be ultimately borne by the sources? Or are you taking a different position?
I think it's more nuanced than that. Section 7411 simply directs EPA to consider the cost of achieving such reduction. And we would say EPA did consider the cost of achieving such reduction. The issue here, that statutory phrasing doesn't dictate any particular kind of assessment. It rather leaves EPA with a range of discretion with respect to how it considers costs and how it balances them against benefits. So we would say the issue here is whether EPA reasonably exercised the discretion that it had in focusing in this rule on the cost to regulated sources as opposed to indirect impacts on the public fisc. And our opponent's argument obviously centers on the point that EPA took into account the generous Section 45Q tax credits. So EPA considered those tax credits, and we think they considered them properly. We don't think EPA was required to prioritize foregone tax revenues over the emission reductions that Section 7411 is intended to achieve.
Can I ask you about that? So of course, the agency has some discretion about what costs and benefits to think about when assessing the costs of this rule. But I don't see how the agency has the authority to consider something that is a cost to the American people a benefit, right? So tax credits are always an expense. They are a cost. They are borne by taxpayers as a whole. So to include that effectively as a benefit of the rule when they are a cost to the American people, I don't see where EPA has discretion to do that. I mean, there's no world of accounting in which a tax credit is not a cost.
With all respect, I don't think it's a fair characterization of EPA's thought process. EPA, of course, recognizes that tax credits and subsidization of industries impose a burden on the public fisc and require that governmental operations be funded elsewhere. The point is that by enacting tax credits into law, Congress, not EPA, has made a legislative judgment that the benefits of the tax credits in terms of stimulating cleaner practices are worth it in terms of the resulting burdens to taxpayers. So the EPA was deferring to Congress's legislative judgment here, wasn't making its own judgment.
No, it's not making, I mean, of course, Congress has made a judgment to subsidize this technology, but that is still a cost of the rule. When the rule imposes, this technology on the industry, the tax credits, the fact that it is economically feasible is because of the tax credits. Without the tax credits, this is not economically justified.
We agree that the tax credits were an important part of the puzzle here and that EPA did consider them. But we think, the most logical understanding of what Congress intended here is that it expected EPA to focus on the cost to regulated sources who are the sources responsible for achieving the emission reduction as opposed to measuring indirect effects on third parties. And I mean, it might, to help illustrate this, suppose that the taxpayer impacts went in the other direction. Suppose installing controls actually resulted in revenues for the Treasury. That might be the case, for example, if a control technology had to be imported and there are tariffs on the import. So you actually would be raising revenues by requiring a particular control technology. I think no one would say in that hypothetical scenario that EPA should be thinking about the revenues to the Treasury as opposed to focusing on the cost to sources. So we would say it's always going to be a context-specific situation, but here, there's no reason to think EPA acted inconsistently with Congress's intent. EPA was mindful of the Inflation Reduction Act, which was, before it. And so it would have been failing to grapple with a meaningful aspect of the situation before it had it not considered the tax credits and Congress's intent in the Inflation Reduction Act. That act reflects that Congress very much wanted to promote carbon capture, and it would be a very odd understanding to think that Congress expected EPA, to regulate, not mindful of those credits. Indeed, we have legislative history rejecting petitioners' precise
Right. Well, I
position.
mean, the act suggests that Congress is seeking to encourage this type of, technological development or adoption of technology, but that doesn't go to the question of how EPA has to think about the costs of the rule.
Well, again, there's no reason to believe that Congress both thought it was very important to address climate change threats, and yet not want EPA to take that judgment into account, where EPA simultaneously had been tasked by Congress with exercising regulatory authority. And if there's any doubt about this, we have, again, the Pallone Statement, which is legislative history.
It's just one member of Congress.
In the context,
It's not like 1980 or something with the legislative histories.
in the context of an appropriations legislation where there are no committee reports, this is actually the only source of legislative history
So
I'm
one
aware of.
member can determine how an entire industry is regulated.
No,
with respect to
I
costs.
don't think it's binding on the agency. I just think it reflects that EPA was acting reasonably here. I also say that petitioners are kind of playing both sides of this issue. Under their view, if they take the initiative to install carbon capture systems and accrue the tax benefits, and that's perfectly fine use of taxpayer resources because they're entitled to the tax benefits. But they say if we're accruing those very same tax benefits and also complying with an EPA regulation, then taxpayers aren't being treated fairly, and that's just trying to have your cake and eat it too. These credits are Congress has made the legislative judgment that the burdens to taxpayers are worth it. And EPA wasn't required to second guess
But
that.
Congress didn't impose the technology, right? So Congress created an incentive to use the technology, which is, of course, within Congress's authority to do. But when EPA imposes a mandate for regulation, it has to consider the costs of that mandate.
Right, but isn't a regulatory landscape where there's only the carrots. There's also the stick that Congress provided to EPA through the Clean Air Act. Congress directed EPA to regulate applying the best system of emission reduction. And we respectfully submit that in this context, it was quite reasonable for EPA to do its cost accounting mindful of those tax credits.
My colleagues don't have additional questions for you. Thank you, Mr. Hostetler. Keller, we'll give you the 5 minutes you asked for rebuttal.
Very much appreciate that. 4 points and I'll briefly wrap up. First, I think there's a very straightforward way to resolve this case at this point. You've heard my friends say, and they also told the Supreme Court during stay briefing, that they were not relying on forward-looking projections. I would urge this court to look at what the rule says. Our brief at page 40 is collecting cites from JA 4, 33, 34, 35, 81, 92, and 129 that say the following, that this rule is engaging in the following: projections, predictions, extrapolations, anticipated improvements, and other forward-looking mechanisms. That's quoting the rule. At this point, the court has to review what the agency's rule in fact said under Chenery. They're saying they're not doing forward-looking projections, but they are. That alone is a basis to vacate. On costs, I do think that this is a fundamental error of administrative law, and that the court hasn't seen a case quite like this where an agency was coming in saying because there are government subsidies, they could ignore costs. I mean, I think my friends on the other side supporting EPA here, I'm not sure that they want that rule if the government subsidies are about defense spending or agriculture subsidies or charter schools or a whole host of other issues. So I would urge the court to take a close look at that issue. On reliability, commenters were repeatedly begging EPA to look at operational reliability and not just resource adequacy. You don't have to take our word for it. The independent system operators, this is JA 1627 to 28, we're saying there's a big difference between just generating power and the ability to transmit it. If I can address slipstreams just a little bit more. First of all, this is all projection at this point. And this is way more than the minor projections that this court's cases have allowed. And so what I'm about to say, we're trying to answer EPA's questions, but it's also not our burden. And this gets back to something has to have been adequately demonstrated. But I would also point the court to JA 1354. This is Minn Kota's comments. Minn Kota is the one that is trying to get the planned Project Tundra off the ground. And they said, quote, carbon capture efficiency will vary when the flue gas stream is at a lower load. You also heard, reference to the Chikanowicz and Hine comments. This is JA 2796. Footnote 7 says a slipstream. The problem with EPA's analysis is it's not linking reliability of the host process to the CO2 capture technology. There were comments in the record pointing this out. And not only that, but every single commenter that was saying there's going to be grid reliability problems, we can't do this. I mean, Project Tundra, the world's largest CCS project, they were telling EPA, we can't comply with this rule. Slipstream, otherwise, no one has done it before, and there are a whole host of comments saying that it can't be done. And if I could just briefly now conclude, ultimately, at the end of the day, the industry, we want carbon capture to work. And Project Tundra is case in point. I think what EPA has done here is thumb its nose at an industry that is trying its best to get this technology to be able to demonstrate carbon capture levels at large scale. What happens? Now we pose this question to the court. What happens in 2032 when EPA's projections are wrong? It's way too late to reverse course. We all want CCS to work, but industry cannot be. This country cannot be stuck if it doesn't work and all of a sudden all coal plants are in violation of this rule. And the statute that Congress wrote here was written in a way to avoid that exact scenario. It tells EPA, you have to show that something has been adequately demonstrated. And when industry has spent 2 decades and billions of dollars trying to get this technology to demonstrate at large scale, and EPA comes in and says, well, in 8 years, you're going to be able to do it. And they keep repeating this mantra that somehow no one would ever try to do this if there wasn't a government mandate. That is just completely belied by the record. Commenter after commenter, and Project Tundra is case in point, but it's not the only case, are saying, we're trying to do this, EPA. We do appreciate the tax credits. That's also very different than a mandate. And an industry taking advantage of a tax credit to try to demonstrate this technology, to then have EPA come back and say that we're trying to have it both ways. We're not trying to have it both ways. We are trying to get better at carbon capture. We're trying to address that problem, but we're also trying to provide reliable electricity for the nation. And if EPA is wrong, there's going to be huge energy deficits with high rates for consumers. And this is all when artificial intelligence and electric vehicles in this country, great technological developments that we all want, are going to increase electricity demand. And if you don't want to take my word for any of this, I would urge this court to look at the independent sister operators amicus brief. They're the ones that maintain the grid. And they said that this rule, quote, will drive premature retirements of generation sources that will threaten the reliability of the electric grid. unquote. EPA has violated the Clean Air Act. We'd ask that you vacate the rule.
Thank you, counsel. Thank you to all counsel on this issue, this set of issues. We'll move on to the next set of issues. Ms. Wood?
Thank you, Judge Srinivasan. May it please the court, I'm Allison Wood on behalf of the petitioners who are challenging EPA's determination that for medium-term existing coal plants, 40% co-firing of natural gas is the best system of emission reduction. I'd like to reserve 2 minutes of my time, please, for rebuttal. Like CCS, the 40% co-firing best system of emission reduction that EPA has identified in this rule violates both Section 7411 of the Clean Air Act and West Virginia versus EPA. But this BSCR is in a different position than we saw with CCS. Here, the issue is achievability. 40% co-firing is not achievable as Section 7411 requires because most coal plants do not have access either to any amount of natural gas or to the amount of natural gas that is required to co-fire at this level.
Ms. Wood, could you speak to the question of when achievability must be demonstrated? Because it seems petitioners are focused on the fact that it has to be achievable today, but the rule doesn't take into effect
Yes.
for some years into the future.
Correct.
So do you agree that EPA has to show that it is achievable by the effective date of the rule?
Yes, it has to be achieved. You know, that is the position of petitioners, but even
It
if
has to be achievable today?
it should be achievable at the time, and they should be able to show that it is achievable at the time that the rule is promulgated and goes into effect.
Doesn't achievable suggest grammatically
Those-
something in but the rule goes into effect in whatever, 2030?
Well, so the rule is in effect now, Your Honor. The timetable for compliance with it is.
Right, so why is achievability, right? Whether the regulated entity can achieve these standards, not keyed to when the rule, I mean, yes, it's in effect, but when the requirements are imposed on the regulated entity.
Because we need to be able to ensure that this standard will actually be able to be met by the regulated entity. Because if they cannot do it on the day that compliance begins, then they're in violation of the Clean Air Act, which is a serious
Okay, so
issue.
EPA then does have to show achievability by the time compliance begins, not the date the rule is promulgated.
Right. And our position is that you have to be able to show that it can be achieved now. But let me explain further with regard to the 40% co-firing. Even if it is supposed to be achievable, on the date of compliance, here you still have an achievability issue. And let me give you an example.
Can I just ask that threshold?
Of course.
That's the question. I do want to hear your argument about why there's an achievability problem, even if you look forward. But if you have a state of the world in which there's literally no dispute that it's going to be achievable by the compliance date, but there's also no dispute that it's not achievable right now. But even the industry, everybody agrees this is where this is going. It's as sure as it is that the night's going to follow the day, that by the compliance deadline, it's going to be achievable. You would still take the position that it's unlawful to impose that.
Look, I think that that's a different situation than what we have here. The language of the statute, is in the present tense. We talk about that in our briefs. But if everybody was convinced that it was going to be achievable on the date of compliance, nobody would be challenging that, and there would be, no basis.
But it would be unlawful, in your view. It would be ultra vires to adopt that.
That is a different factual circumstance than what we have here. And what we have here is a situation where more than half of the plants cannot achieve this standard. what EPA says in the rule is that the 40% co-firing BSCR, that what is required by that, they say, and this is a quote, it would require only minor changes to the unit's boilers. So you go, they change the coal plant's boilers, the compliant state comes. If you don't have natural gas coming to the plant, you can't achieve it. And the build out of that type of infrastructure has never been required under Section 7411 before. What we're talking about here is the construction of thousands of miles of natural gas pipeline at a cost of $11.5 billion that is actually the construction of an entirely separate source category that's regulated under a different provision of Section 7411. The difference is that what EPA has always said, and its position has always been, is that a standard of performance has to be the least common denominator. This court has said it has to be achievable by the industry as a whole. And yet, when we look at the rule, what we see is that EPA's data show, we're taking their numbers here, that more than half of the existing coal plants don't use gas, either as a fuel or as a startup source. More than a third are located at a facility that doesn't have any connection to a natural gas pipeline. And nowhere in the Clean Air Act does it authorize EPA to require the construction of an entirely different source category. Now, what EPA does say here is, they point to, an example, and they say, well, a lot of times you have to take other steps to be able to achieve the standard of performance. And the example that they give is they talk about flue gas desulfurization at a plant. And they talk about the fact that, look, we have required before where facilities may need to, there's going to be waste afterwards. So they're going to have to come up with methods offsite to treat it, to transport it. So how is this different? The difference, and it's a key distinction, is that the ability to meet the emission limit does not depend on those other items. So for example, if you took your scrubber waste and you did not dispose of it properly and you let it pile up, and I'm certainly not advocating for this, you would be violating other environmental laws, certainly. But when you put the scrubber on that plant, it's meeting its standard of performance under the Clean Air Act, under 7411. And here, that doesn't occur. That does not occur unless you have constructed the thousands of miles of pipeline to the facility. And the next issue is that even if EPA could be authorized to construct those thousands of miles of pipeline, which we say they cannot, the timeline that is being provided here, which requires that construction, that build out to be done 5 years from today, is impossibly short. And it's based on unrealistic and flawed assumptions. First, petitioners argue that EPA has waived its argument with regard to the timeline because it failed to respond in its brief. There are supplemental briefs on this issue though lodged with the court. But regardless, the record shows that EPA's assumption that a pipeline can be permitted and constructed in 3 years, and they say that will occur from June of 2026 to June of 2029, is arbitrary and capricious. EPA takes the most sunshine and roses view at every turn of its consultant's report. So ICF says, yes, that on average, you should be able to do this in 3 years. But EPA is ignoring ICF's language where it says that if a plant experiences difficulties, it could take up to 5 years. Well, if it does take up to the 5 years, then you miss your deadline. You've missed it by 1.5 years and you're too late. And the 1 year extension that you may be able to get under this rule is not going to save the day. It's not enough and it's not guaranteed that a source can get it. EPA also assumes throughout everything to do with this BSCR that we're looking only at lateral pipelines, which are short ones that connect to an existing pipeline. These are easier to build, they're shorter, they're less controversial to permit, and EPA failed to assess what would happen if it was not a lateral pipeline. And even though these laterals do tend to be easier, it's not always the case. As this court is well aware in seeing, cases where pipelines are controversial and are going on for years.
Ms. Wood, at the outset, you mentioned that this requirement also violates West Virginia. Is that an issue that one of your co-counsel is going to take on, or is that?
Mr. Williams is going to talk about that, but I will just briefly say that here, the reason the 40% co-firing violates West Virginia is because it explicitly is requiring generation shifting. It is requiring a coal-fired power plant to turn into a hybrid coal-gas plant that burns at least 40% natural gas. And the Supreme Court said that EPA does not have the authority to decide how much of a switch from coal to natural gas is practically feasible. That's at 597 US 729. And yet here, EPA is doing exactly that. It's saying that the amount that is practically feasible is 40%. And the Supreme Court also said in that case that it doubted that EPA could order a coal plant to become a natural gas one. Yet again, that is what we're doing here.
Colleagues don't have additional questions at this point. Okay, thank you, Ms. Wood. Hear from EPA counsel. Miller.
Your Honors, EPA appropriately identified 40% co-firing as the best system for medium-term plants. There were a number of objections asserted by my friend, and I'll try to address each of them in turn. And I'll start with the statutory arguments.
I could first just ask you a question. I don't see anything in the rule about why EPA chose 40%. Right? And there are places where it acknowledges that the states could impose a higher percentage, right? Because that would lead to greater emissions reductions. So why 40%?
I think it was trying to come up with a balance that would be cost reasonable. And there were cost constraints here, because
the main costs are the facility builds out and the infrastructure. It's not the incremental emissions reductions, right? So why 40%? Is that just sort of what you think can kind of pass muster under West Virginia v. EPA? I mean, I don't see any explanation for 40% where higher rates would produce more emissions reductions.
I don't know that EPA specifically assessed higher percentages. That I can check on that, but the conclusion was reached that 40% was feasible and cost reasonable. And so that's where the agency landed. And if the more modifications you're doing, the more costs are going to go up. And so I think there might have been a cost issue.
Aren't the primary modifications, though, the infrastructure modification? I mean, it's not about 40% or 50%. It's about the fact that some plants that have no natural gas hookup are now going to have to be partially fired with natural gas.
Right. But the pipelines might need to be bigger in the context of.
Does EPA say any of that in its rule?
I'm not quite sure whether there's a specific analysis of higher percentages, a comparison, and I'll check on it.
40% just an arbitrary number?
No, it's not arbitrary. It's a system intended to secure substantial emission reductions, and it will secure substantial emission reductions. It's when implemented, will achieve a 16% reduction in carbon dioxide emissions from each facility, significantly improving their performance. That's a productive system of emission reduction.
That doesn't say why not 50 or 60 or 70%.
I mean, I grant that conceptually you could go to a higher percentage if the cost metrics and the feasibility metrics worked out. And so it's not impossible to conceive of that as a system of emission reduction. With respect to the statutory interpretation issue that was teed up, this kind of fuel switching is a permissible system. They have my friend hasn't articulated any coherent construction of section 7411 that would preclude it. Our opponents have invoked the West Virginia opinion, but that decision only reinforces EPA's authority. As the Supreme Court noted in the West Virginia case, fuel switching is a traditional at the source measure that causes the regulated plant to operate more cleanly. And as such, it falls squarely within the heartland of section 7411's coverage. And EPA has long considered and applied fuel switching in its section 7411 rules. So there's no textual basis to reject it. Obviously, West Virginia ruled out a grid level system, which was a system intended to require certain plants to operate less.
Mr. Hostler, how is this fuel switching in the way that fuel switching has been discussed in the earlier cases especially for a plant that has no natural gas at all? I mean, how is that fuel switching in the way it's been understood, where it's really more like, you go from leaded gasoline to unleaded gasoline. Here it's like a completely different, source of fuel.
Right. I think it's important to understand that these steam plants require very minor modifications to fuel switch. When we're talking about a steam plant, and I'll try to simplify this as much as possible, you're basically boiling water to produce steam, to drive a turbine, to generate electricity. And you can boil the water using different fuels without any major transformation of the plant. So, it's still a steam plant when you switch the fuel. It still retains all the same fundamental attributes. This is not like converting a steam plant to a gas-fired combustion turbine, which would be a different kind of plant. And those are the kinds of plants that are regulated as new sources in this rule. That would be a much greater degree of modification. So we're really talking about taking a steam plant that's kind of a hybrid plant to begin with and converting it to a steam plant.
Most of them are not hybrid plants, though. Isn't that right?
Presently, almost half the fleet has the capability of firing some degree of natural gas.
So half does not have the capability.
Correct, but then it's an achievability issue, and we submit that it is quite achievable and feasible to construct short lateral pipelines to connect to the mainline interstate gas network and secure the gas. So we're not asking them to do something that's impossible to do. It's very achievable, and EPA did a thorough analysis of the costs and determined it wouldn't be cost excessive.
I think the question in my mind is that, and this I think will continue in the next argument too, but is that tantamount to generation shifting?
No, I think it's inapt to characterize 40% co-firing as generation shifting. When that term is used, generation shifting, you're really talking about how it was used in the Clean Power Plan, where you're shifting generation from one plant to a different one. So you're subsidizing your competition. For example, in the Clean Power Plan, a coal plant would have to be replaced by a gas plant or by a solar plant. 40% co-firing doesn't entail any kind of shifting to another plant. It entails substituting a minority of fuel from coal to gas within the same plant under control of the same operator. So the steam plant with minor modifications is continuing to operate much the way it always has, continuing to generate power through spinning a steam turbine. So it's much more appropriately characterized in our view as fuel switching, not generation shifting.
Can I just ask this so I can understand the way this works physically? So suppose the percentage figure were 80% instead of 40%. Would everything you just said still be true, which is that it's still considered a steam plant rather than a gas plant, even though it's 80% by hypothesis gas at this point, because the way that the technology works is still the way that a steam plant works, as opposed to the way that a gas plant would work?
Yeah, I mean, we in our brief characterize this fleet of plants as coal plants for simplicity, but it might have been more appropriate for us to characterize them as steam plants because that's what they are. And now if you went to a higher percentage, it might be a more difficult case for us on the record because maybe the degree of modifications would be more extensive. But we don't think the outcome—
In terms of whether you call it generation, I'm just thinking conceptually whether you would—
It's not generation switching not under any circumstance, but whether the amount of fuel switching is
doable.
Doable, right. And let me address Yeah.
Question about that. So EPA is not able to redefine a facility, right? So at what point does a facility become redefined in EPA's view? So in the brief, EPA asserts the authority to make changes to aspects of a facility that are either minor or significant. Well, how is that consistent with the statute?
Well, first of all, there's no prohibition on redefining the source in the statute. I think you're referring to a policy that EPA has applied in a different program, and petitioners have urged EPA to apply that same policy to this program.
But that program, whatever the best available control technology, that provision of the statute refers back to 7411, which EPA is relying on here. I mean, the provisions are connected, and under the BACT provision, EPA can't redefine a source, and that provision links back to 7411.
More importantly, even if you applied that policy, which again is a policy, we're not talking about law here, that policy, as EPA understands it, wouldn't preclude this kind of co-firing. That policy doesn't preclude changing some minor aspects of the facility. It's a policy used by EPA only to rule out very major changes that fundamentally redefine the basic design and purpose of the source.
So perhaps following up on Judge Srinivasan's question, what if it were 90% gas firing? Would that be redefining the facility?
I think it would.
Is there some limit on the ability of EPA to change one facility to another?
Well, I think one way of looking at this is to focus on footnote 3 in the West Virginia opinion, which is dicta. We do think the Supreme Court left this issue open for another day. But the concern the Supreme Court expressed in that footnote in dicta is that if you went to a high percentage of fuel substitution, maybe you'd be causing the existing plant to cease to exist. And we would say it's a record-specific inquiry whether a particular degree of fuel substitution is causing a plant to cease to exist. So the correct way for the court to approach that issue, when and if it's presented, would be to look at, what degree of modification is this system doing? And are you effectively causing the existing plant to disappear? So for example, to take one extreme, suppose you were taking a coal plant and requiring it to become a nuclear plant. You'd have to tear the entire thing down and start from scratch. Now that probably would be impermissible because you are causing the existing steam plant to cease to exist. On the other end of the spectrum, suppose, the plant's already configured to burn multiple types of fuel. And you're just telling it, well, they don't have to do anything. They don't have to spend a dime. They just swap the fuel. In that circumstance, we say it's totally fine to go to 100% fuel substitution. You're just switching the fuel. So it's a record-specific inquiry in our view.
And then what about the 40-some% of plants that don't have a natural gas hookup currently?
Right. And so we'd say this is a record issue as to whether it's feasible for them to get to 40% and do that hookup. And we think it is. We're talking about relatively short lateral pipelines to connect to the existing. That in the West Virginia opinion, as part of its discussion of fuel switching, it cited to a portion of the Clean Power Plan preamble where EPA was discussing this very system of co-firing with natural gas at coal plants. I mean, why would the Supreme Court have cited to that discussion if it wasn't trying to, draw a contrast and flag a system that would be permissible by way of contrast with what the Clean Power Plan was doing?
I just have a question about, you said what's wrong with generation shifting is it identifies market shares. And if what EPA had done here would say, every coal plant must now be a 40% gas plant, it would seem kind of unavoidable that was setting the market share, the resource mix as between coal and gas. Would that not be a problem, or is that somehow different from what EPA did here?
No, I think fuel switching is a perfectly permissible pollution control measure. And if by switching a fuel, you're reducing pollution, that's well within the framework of Section 7411. I don't think you can make the distinction you're trying to make where fuel switching with like a different blend of the same type of fuel is fine, but switching to a different type of fuel is not fine. That's a constraint that's nowhere in the statutory language, and you'd be conjuring an extra statutory constraint there.
What's the kind of on the ground difference there from the hypo that Judge Garcia posed? If the agency has a choice, you could either say 40% of the plants have to be gas plants, or you could say, well, equivalently, 40% of the throughput has to be gas throughput. And is there an actual difference between those? And I'm putting to the side, by the way, one other item about this that I want to ask you about, which is I'm not even sure the hypo works because this only applies to medium term. But just put that to the side for 1 second and just address it on the terms that I think Judge Garcia posed it, which is what's the difference between saying 40% of the plants have to be gas plants, which seems like that's exactly what the Supreme Court said the agency can't do. If the agency comes back and says, oh, okay, we can't do that, but what we'll do is basically the same thing, which is to say 40% of the stuff that goes through has to be gas at any particular plant.
I think those are just two very different animals. I mean, if you're requiring 40% of steam plants to become, fueled with 100% gas, that would be a harder case for us. We would have to show that the modifications required to do that were, acceptable. And I grant you that would be harder for us. But this system is causing each individual plant to operate more cleanly. And that's precisely what the Supreme Court said this section is intended to do. So I don't see how you can rule out this system without casting doubt on any kind of fuel switching. And fuel switching has been a regularly applied system of emission reduction.
I think we'll have more, I will at least have more questions for you after Mr. Williams argues, but Ms. Wood focused on the point that something novel about this is the extent to which it requires off-site infrastructure build out. It seems like that's kind of an unavoidable reality here. This is not the same as needing to find somewhere to dispose of the sulfur dioxide. It's going to be a national infrastructure build out of at least dozens of pipelines. And why isn't that something that should matter in terms of our major questions thinking that this is novel in the type and extent of off-site infrastructure development that EPA is requiring?
The scope of the infrastructure might be different than in prior cases, but conceptually, this is really not different than other systems that involve transporting materials to and from the site. If you've got a sulfur dioxide scrubber and you're generating waste, you may well have to create infrastructure to transport that waste to an off-site disposal location. Systems of emission reduction commonly require the need for transportation of materials to and from the site. And I would also say, we're not asking these plants to do something that's outside of their wheelhouse and outside of their day-to-day business operational experience. I mean, if you're a coal or a gas plant, you know how to get materials to the site. You have to run a successful plant. If you're a coal plant, you may well have had to construct railroads to bring the coal to the site. If you're a gas plant, you've been constructing pipelines to get to the site. So we're looking at the existing fleet plants being regulated, and almost half of them already have some infrastructure because they're co-firing already. Over 24 plants are already co-firing at levels between 40 and 60%, or have co-fired at that level. So we're not asking this regulated fleet to do something that's outside of their normal business experience.
Okay, I think we'll probably explore these issues a little bit more when you stand back up in a little bit. But for now, thank you, Mr. Hostetler. So we'll give you your 2 minutes for rebuttal.
Thank you, Judge Srinivasan. First, a nuclear plant is also a steam plant, does the same thing. It heats water to make steam to generate electricity. EPA has historically always treated coal plants and gas plants differently, even though they were both steam plants. They have different NSPS, new source performance standards. Second, with regard to fuel switching. Fuel switching is mentioned in the West Virginia opinion as a traditional tool, but that traditional tool has always been understood to be a change between the same type of a compatible fuel. So something like using a lower sulfur coal. In the examples that EPA provides in its brief, it's switching to a ultra low sulfur oil. It has never been changed from coal to gas, to totally different things. And as for the citation by the Supreme Court to the Clean Power Plan, they do say fuel switching, but they very carefully and I think intentionally omit and do not cite the parenthetical that says natural gas co-fire. That is removed from the West Virginia opinion.
Ms. Wood, would it be a problem if EPA's 40% co-firing only applied to the coal plants that already have natural gas co-firing?
Look, under 7411, EPA has the ability to subcategorize, and it could have potentially subcategorized that way and only applied this to the plants that have access to the sufficient.
They didn't, but do you think that would be contrary to the statute?
No, I don't. I think that
You
would have,
don't?
I think they could have subcategorized it that, well, let me take a step back.
So you think that
No,
would be-
that would have still violated, I think that still would have violated
Would it have
the
violated
West Virginia because
Would it violated the statute, or would that just have been, unreasonable or too costly?
it would violate the prohibition against generation shifting that.
For a plant that already uses both types of fuel, would that be generation shifting? How would that be generation shifting?
Because when plants tend to use this, it is usually for startup shutdown, but more importantly, it would again be EPA dictating the optimal mix of fuel here and saying that you have to now combust at the 40% level rather than the source wanting to decide that for itself. So it is again doing exactly what the Supreme Court said you cannot do under the Clean Air Act, which is dictate the mix of fuels. In terms of the clean.
That would be true even if it's not only the case that they're already demonstrating the capacity to co-fire gas, but they're already doing it at 40%. It would still be a problem under the statute, in your view, if all EPA said was, keep doing exactly what you're doing already.
Right. Look, there's a difference between choosing to do that and being mandated to do it.
And you think that would be
I think that it would run afoul of West Virginia. In terms of could they have subcategorized this, putting aside the West Virginia problem under the statute, that might have been a possibility. But you still would have had the West Virginia issue, which is why I said.
So the arbitrary and capricious challenge wouldn't probably, many of those arguments would not apply to plants that already use both.
Right. Now, and EPA didn't do that here, as
I
you know.
understand. Trying to understand
Right.
how the
No.
arguments map on.
No, and then that would not have, but it still would have had the West Virginia issue. One of the things that counsel for EPA said was that, this was just very minor changes. That might be true at the boiler. It's certainly not true that building a pipeline, thousands of miles of pipeline, is minor. He also said that building short lateral pipelines is not impossible. petitioners are not arguing that this is impossible. It's certainly possible to build pipelines. People do it all the time. What we're saying is that it is outside the EPA's authority under the Clean Air Act. And even if it was not outside the scope of the Clean Air Act, you cannot do it on the timeline that EPA has put in place, nor has EPA adequately examined the capacity of the pipelines it's trying to connect to. Finally, he talked about the idea of a plant ceasing to exist, in that language from West Virginia. The coal plant does cease to exist here. It's no longer a coal plant. It is instead a coal gas plant. And this, as Judge Rao intimated, is an improper redefinition of the source, changing it from what it is, a coal plant, into a hybrid plant that is impermissible both under West Virginia and under the Clean Air Act.
Thank you, counsel. We'll now move on to the last set of issues. Mr. Williams.
Thank you, Your Honors. Good morning, Your Honors, and may it please the court. In the rule here, EPA asserts transformative powers in two distinct ways. First, EPA invokes an ancillary provision to tackle a major question, namely how to shape the national energy grid. But EPA lacks any clear authorization from Congress to rejigger our nation's power industry. Second, as to existing facilities, EPA strips states of congressionally preserved discretion and relegates them to bit players in the regulatory scheme. But this approach gets it exactly backwards, as Section 111D contemplates that states will take the lead on the implementation side of existing source regulation. So for these additional reasons, this rule is unlawful and cannot stand. Now, moving first to the major questions doctrine, make no mistake, the rule reflects an assertion of transformative authority. Based on prognostications about what might someday be possible, EPA is forcing facilities to do one of three things. First, even assuming facilities could somehow implement this purported system of emission reduction, they would be thrust into the role of pipeline operators and carbon storage facilities. Remember that West Virginia v. EPA cast a skeptical eye towards EPA's efforts to force existing facility operators to reshape their businesses and plunge into new sectors in the name of emission reduction. But that's ultimately what this rule tries to do.
Ask you, why, what does the major questions doctrine really add here, right? So if the arguments that the other counsel have made against this rule apply, then what extra work is the major questions doctrine doing here?
So I think, Your Honor, that if their arguments did succeed, the court wouldn't necessarily have to reach the major questions issue. But I think it does confirm their reading of the statute. And I think maybe more importantly, it informs the court when it comes to even beyond the express language of the statute. The court has to ask itself whether there is a clear congressional statement, not merely plausible language, but a clear congressional statement that what EPA wants to do here is actually greenlit by Congress.
So in West Virginia v. EPA, the Supreme Court suggested that, technology forcing, regulations on particular sources are the sort of thing that's within 7411. So what about that argument? I mean, so here there's arguably technology forcing requirements on particular sources.
Right. I would not say that it's true that the Supreme Court greenlit all technology forcing standards.
Not all of it, but they recognized that was sort of the traditional heartland of Clean Air Act regulation.
It very much can. Absolutely, Your Honor. But I think the court nevertheless took a sort of clear-eyed practical approach to what these rules actually did. And so I think the court looked at two things. One, it looked at the specific statutory provision that EPA was purporting to invoke and said, does that really line up with the sort of transformative nature and effect of the power that EPA is trying to assert? And I think that's the same sort of disconnect that we see here, where we see an agency both trying to impose a new requirement to enter the pipeline industry, the storage facilitation industry. We see a requirement for these plants to shift over to natural gas operations. And barring any of that, we see a requirement that they just simply close, which is exactly what West Virginia EPA has said cannot happen. And I think it's really that transformative nature that trying to change the composition of the national grid itself? That's really what
But
the
where
Supreme
does
Court
it
took
fit
issue.
into that architecture that this applies, as I understand it, just to the medium-term subcategory?
So I think
Because, I mean, if something's, that's medium-term, meaning it's a coal plant, but it's a coal plant that's slated to stop at a finite time in the future by 20, I forget the year, but
right, 2032, I believe.
2030.
Right,
30 and 9.
30, excuse me, yes.
But in any event, it's some particular year. But if it's going to stay a coal plant beyond that, then it's just, then you're in 90% land. And that's, I know there's separate challenges to that. But
Right.
And for these purposes, those challenges fail
Well,
for purposes of the hypo. And then so it only applies to this subcategory. So it's not generation shifting in the same sense because it's for those entities that self-select into this category.
So I think the problem for EPA, though, is for each of those categories, it tries to tackle the major question without clear congressional authorization. The reason being that even if we're a 90% CCS land, now you're still forcing coal plant operators to become pipeline operators and still force them to become storage facility
Right, but I'm
operators.
just assuming that that challenge fails. So let's suppose that, just for argument purposes, I'm
Right.
not saying it fails.
Sure.
Obviously, I'm not saying, I'm just saying to understand conceptually where this part of the argument lies. If the 90%, the challenge to the 90% CCS requirement fails, and then the 40% co-share only applies to the medium category,
Right.
where does that leave us vis-a-vis West Virginia, not vis-a-vis West, vis-a-vis West
trips me up.
Virginia? Because it's not talking about a forced generation shift. It's talking about that category that's in this medium band.
I think it is a forced generation shifting category, Your Honor, because they're confronting the market as it exists, right? So this medium term category, plants sit in that category one way or the other. So when EPA approaches that medium term category and says, once you land there, you're in 40% co-firing land. Now we're in the same situation that we saw in West Virginia, where EPA is making express decisions about the sort of composition of the energy portfolio. And as I think a couple of you recognize, fractions are transitive. So a 40% across the board is the same as 40% at each facility. And so in that way, it's actually the identical judgment that the Supreme Court said hands off, no touch.
And would you make the same argument about 10%?
I think that's a much closer question. I know it's the worst answer to give as an advocate, but I think it's a much closer question because then we would have to look specifically to where the market exists today. So take, for instance,
No, but in terms of generation shifting,
Right.
if the idea is that 40% for West Virginia purposes
Right.
can amount to generation shifting,
well, so
would that not be the case with 10% also?
the reason why I have to say it's somewhat of a technical answer is because the 40% number that you keep hearing from EPA, 40% have some amount of natural gas. They use that for a relatively limited purpose, right? They use that often for startup or for standby operations. If EPA came in and said, we want that narrow population of plants to do a little bit more, and their operations don't change in that sense, the composition really doesn't change in that sense, I think that's a much closer question that's not generation shifting than what we see here, where every natural gas plant, or excuse me, every coal plant is becoming a natural gas plant across the board. It's an across the board shift. It's
No,
the
but
very,
I guess maybe I'm either not understanding something or I'm not articulating the question correctly, and it could well be the
It's
former.
probably
So
my
if that's
fault.
the case, tell me. But all I'm saying is instead of a 40% co-fire, it's
Right.
10%.
I think in that
That's
instance,
still across the board.
Right.
In the way that you're thinking about it, I think.
so if it's an across the board 10%, that's still an express determination by EPA about the composition of the national energy portfolio. And as we understand West Virginia, and I think the court was quite clear, EPA has not been empowered by Congress to make those sorts of deliberative judgments about how the national energy grid is to be composed. They're supposed to help the existing energy portfolio improve its performance for the benefit of emission reduction, not just supposed to change the board, wipe the board clean and start over for their preferred composition. So
Mr. Williams, would your case be harder if EPA had chosen, or would it be different if it was 60% co-firing? So arguably EPA is saying, well, this is still more a coal plant than a
Right.
gas plant. You know, it's 60% coal, it's only 40% natural gas.
right,
So is that generation shifting? It's still a majority coal. I mean,
right.
they don't really say why they've picked 40%, but I assume that has something to do with it.
I have the same suspicion, Your Honor. I think that 60% would obviously be a more egregious violation of this prohibition against generation shifting. At the same time, if we actually look at the Clean Power Plan, it didn't apply some majority percentage rule. It didn't say that it was forbidden generation shifting because it asked plant operators to move to more than 50% renewables. It just said, ultimately, are coal plant operators being asked to change their business and subsidize what they term competitors, but really it's just subsidize a different form of generation. And that's exactly what's happening here. It might be happening at the same plant facility. It may be that they don't have to go down the road and buy a few credits from a wind farm, but they're still having to subsidize a different type of generation, which is what West Virginia said is a no-no.
Council, I agree there's several different threads in West Virginia, but one of them, and maybe a dominant, was this idea of a mismatch, because the
Right.
court saw EPA as effectively starting with considerations of the resource mix
Right.
and how bad prices could get, and trying to mastermind the optimal mix of energy sources.
Right.
And the court says that gets it backwards. And then I think EPA would say what we did here is exactly the opposite, right? We started at the plant level and came up with the best way of reducing emissions at that plant, 90% CCS. And this 40% co-firing requirement only comes in if you're not going to operate long enough to amortize, to afford the CCS on their telling.
Right.
And so when you get to this 40% co-firing requirement, it's a little bit hard to see how that is doing the thing that was problematic in West Virginia, which is masterminding the overall resource mix. Nobody really seems to know how many plants are in this category, but it's certainly not all the coal plants. It seems like it is going to be, EPA thinks far fewer plants will fall in this category than will do CCS. And so I guess I think a distinction might be that there's not the same mismatch in EPA's expertise here. And I'm wondering how you would respond to that.
I guess I'd have two answers, Your Honor. One is that we are not just focused on the 40% co-firing. So you really have to take a holistic look at what this rule does in all three categories.
But that confused me, because
Okay,
I don't
fair.
think in the brief, or just can you clarify, are you arguing that carbon capture is out as a system of emission reduction under the major question doctrine?
Yes, and what it requires is for plant operators, again, to assume all of these additional enormous responsibilities to operate pipelines, to operate storage facilities, to do all of these things that are novel constructions of responsibilities of plant operators under the Clean Air Act. And ultimately, it's not just West Virginia, but every other major questions case that asks whether it's a novel and transformative imposition of agency power that's being presented here without a clear statement, clear authorization from Congress. So in that way, that first category, that CCS category, does exactly that by forcing coal plant operators to become pipeline facilitators, to become storage facilitators, to basically rejigger their whole business to serve EPA's desired ends. That's a very different thing than just a stack level emission control.
Right, okay. And if we look at 40% co-firing,
Right.
more in isolation, can you explain, there's this back and forth about whether this is sufficiently like switching from high sulfur to low sulfur
Right.
coal. And I think somebody might say, you're equally switching the fuel input in that case. The plant wants to use high sulfur coal and EPA is forcing it to do low sulfur coal. Why is the tripwire going from coal to gas?
I think part of it, Your Honor, is that major questions doctrine often looks to what's traditionally understood by the agency and how the agency has approached its powers in the past, how courts have approached the agency's powers in the past. And traditionally, this agency has always made a distinction between coal, natural gas, whether it be in the new source performance standards, frankly, in most every category of how they approach these facilities. They don't just do this sweeping steam generation category that you've heard today. They draw a real distinction between the nature of these operations. And I think given that longstanding understanding, it is entirely fair for us to draw a line between coal and natural gas, just as EPA has done for years, and switching from one type of coal to another. I think it just reflects that traditional
Can I
understanding.
just ask you a practical question? So in the industry, there's a substantial percentage of plants that co-fire. Now, I know there's some that don't, I get that, but there's a substantial percentage that do, right?
So there are about 40% as I understand it. And I want to be clear that that's only for a rather limited purpose, which they use it for startup and for standby. There's about, I want to say something in the neighborhood of 5% that really co-fire to any substantial degree within the industry.
And for those plants that co-fire, are they thinking we're now a different kind of plant, that we used to be a co-plant and we used to be a coal plant, or we used to be how
Well,
would you categorize it, but now doing something fundamentally different so that we're a different category of plant?
Right. I think that's why it was important to make that distinction between the plants that use it for startup and standby and others, because for those that use it for startup and standby, I'd say no, they view themselves as a coal plant because the sort of marginal use of natural gas facilitates the use of the coal. I think for those that sort of do true co-firing, they would probably put themselves in a hybrid category. And I think that's the category that EPA is effectively pushing all these medium-term coal plants into. They're making them become this different category of a hybrid coal natural gas facility. And again, that's what the Supreme Court expressly said in a footnote that they doubted EPA had the power to do. I see that I'm running over.
Can I ask a question
Please.
about federalism?
I was hoping we'd go there, yes.
So most of the petitioners' arguments on the federalism issue seem to be about the standards that are in EPA's implementing regulations.
Right.
And obviously those implementing regulations are incorporated into this rule, but the implementing regulations are being, challenged in a separate litigation, where
By us, yes.
yes, where that case is going to be heard, I think, next year. And so, so can the court reach those issues here? I mean, given the way EPA has pulled these things apart in separate rules. So I'm just wondering how we should be thinking about that.
Sure. I think you can and you should, Your Honor. We recognize that there is overlap. That's undeniable. But I think this is an especially pernicious application of the implementing regs that distinguishes it from the challenge to the implementing regs more generally. I think maybe the best example that I would give you is the way in which they applied rule-off and other factors, or rule-off rather. I think because in this context, they really constrained our ability to consider remaining useful life and other factors in a way that was even more aggressive than I think was suggested maybe in the initial implementing regulations.
And is that because they set rule off in this
Well,
rule?
they did several things. They set rule off, then they said you have to use our particular criteria. Then they said, here's a bunch of stuff we've already considered that we've effectively taken off the board. And oh, by the way, we've subcategorized. So now we think remaining useful life isn't even in play anymore. And it's all those combinations of things that I think really puts this in a different category than maybe even the implementing regulations, which are problematic enough. I think it's ultimately what's the combination and the specific application here that leaves the states without any room for the reasonable judgment that the statute expressly contemplates. And then you pair that with the presumptive standards as well, and the presumptive standards, of course, being a major focus of those implementing regulations. Now we're talking about a whole new situation, right? Where it's not just this degree of other factors discretion. They're completely taking state discretion off the board entirely. So given that kind of unique application, I think it is appropriate for the court to go ahead and address those issues here.
And how would that then intersect? I mean, if we were to reach that issue here, how would that affect the separate challenge to the implementing regulations?
Well, if anything, I think it might make more sense to address it in the specific application here. It's almost like an as-applied constitutional challenge, right? Mm-hmm. We can say we see specific issues in this application that require us to strike it down here, and then we'll leave it for another day whether there's really any set of circumstances in which the implementing regs can properly apply. We think we're going to win that too, but that's a broader question that I think could appropriately be addressed after the as-applied challenge. So I see that I'm out of time.
One thing I was trying to get at with my convoluted question earlier is one way of thinking about the problem in West Virginia is that EPA reverse engineered emission limits from target market shares. Do you think there's any plausible story that that's what they did in this rule?
So I think one can only look to the effects and the actual outcomes of what happened here. I don't think that West Virginia imposes some sort of scienter requirement. It's not a pretext case. It doesn't require us to go into the record and say, aha, they were up to something.
It does suggest a difference between direct and incidental. And so how would you say that this falls on the wrong side of that line?
It does suggest a difference between incidental. We would say that incidental isn't some sort of backdoor way of imposing a scienter requirement, though. It's just a practical recognition that sort of de minimis impacts on the market can themselves not be assumed to amount to a major question, which I think is, again, sort of practical, clear-eyed, common sense approach to this. We would say that this is far more than incidental, especially when you pair all three of those categories together. You have one category where coal plants are closing down. You have another category where coal plants are becoming something else. And you have a third category where coal plants are having to become pipeline operators. And again, none of those are incidental effects together or separate. So in that way, we get away from that sort of incidentalism concern that West Virginia had. We actually were the ones to suggest the incidental standard, so I apologize for giving you that poison to deal with. But I think it really is just a clear-eyed acknowledgement of a de minimis effect isn't enough to trigger the doctrine.
Just one other question. So West Virginia is also challenging the subcategories here and the flexibilities, and I'm wondering how that works in general, like what the limiting principle on that is, because clearly it's good regulatory practice for agencies to consider differences between regulated entities when setting standards for emissions or, almost any other regulatory thing. So if we were to agree with petitioners here that this kind of subcategorization was inappropriate, what would be the limiting principle on that? And wouldn't that be problematic for regulations down the road where it may be desirable for EPA to create certain kinds of subcategories?
So we don't disagree that they can make subcategories. We only disagree with the notion that they can subcategorize based on the notion of retirement dates specifically. We're looking, the limiting principle is really the language of the statute itself, 7411B2, which says that the administrator can distinguish between classes, types, and sizes. And that, of course, is specific to new sources, but we think it maps over onto existing sources as well. So we don't take issue with the notion that you can draw distinctions. We just think that the distinctions have to be made based on the labels and the criteria that Congress has provided for them. And retirement date is a result of market forces. It doesn't fall within classes, types, and sizes as Congress contemplated.
Thank you, counsel. We'll give you a little time for rebuttal.
Hello again.
Stedler, welcome back again.
If you'll indulge me 1 second, I did want to respond, Judge Rauda, your earlier question as to whether EPA considered higher and lower percentages of co-firing. That's at Joint Appendix 4949 to 4950. It explained why 50% was too high, why 30% was too low. Moving on to major questions. This rule does not present a major questions case, rather falls within the heartland of EPA's standard setting authority. And of course, the stay motions panel already visited this issue and held as much, saying that EPA has claimed only the power to set emissions standard limits based on the application of measures that would reduce pollution by causing the regulated source to operate more cleanly, a type of conduct that falls well within EPA's bailiwick. We think that holding was correct. We don't think you need to revisit it. Indeed, we don't think there's even any interpretive dispute at all here that you really need to resolve. We think all of the issues presented in this case are properly viewed through the prism of the arbitrary and capricious standard. And as the court noted earlier this year in the Save Jobs USA decision, the major questions doctrine is just a tool of statutory construction. So if you don't have a statutory interpretation issue on the table, then that doctrine has no role to play in the analysis.
Whether you call this major questions or not, we still have to contend with what West Virginia said is verboten. And what West Virginia said is something that doesn't fit within the compass of this authority is generation shifting. And so then the agency has its argument as to why this is not tantamount to generation shifting. And on that, what role, if any, does it play in your analysis that the 40% co-fire requirement only applies in the medium category?
Well, first, consistent with my earlier argument, we would say that even if that were the only system of emission reduction on the table in the entire rule, that would be permissible. But I do grant your point that it seems particularly not to be generation shifting here, in as much as it only applies to plants that opt into that subcategory, and plants are perfectly free to simply install carbon capture systems and meet the long-term standards. There's no requirement that they co-fire.
So I understood, is it your position that a 90% or maybe 100% shift to gas for coal, that's prohibited by the statute?
My earlier argument was that that would be a record-specific analysis if you're talking about fuel switching at a particular plant.
Right.
Everyone agrees.
So even that under West Virginia would not be, footnote 3 is just dicta, and you can
Exactly. They didn't reach, they left the issue open for another day. And, you can interpret that footnote different ways. It was dicta, and that issue hasn't been reached, and you don't need to reach it to resolve this case.
I guess the pretty clear rule that they are offering is you just can't require a shift from one type of fuel input to another. And they say that all the past examples don't fit that mold. And for that reason, this is a major question because you could ratchet it up to 100%, even though you're doing 40% now. And I'm wondering what that gets wrong.
I just don't think there's a statutory distinction that can be meaningfully drawn here. Like consider if you were going from high sulfur coal to low sulfur coal, and that was the best system. That would have probably big market shifting effects because certain plants are probably better positioned because they're closer to the low sulfur coal. Any pollution standard involving the power industry is going to impose economic cost on the regulated sources. And that's, intended. It removes the externality. And those market shifting effects are unavoidable, but that's not the purpose of the rule. The rule, EPA's charge is identifying the best system of emission reduction that will cause the regulated plants to operate more cleanly. And so, we would say the kinds of distinctions you're contemplating, Judge Garcia, just can't be reconciled with the statute without sort of tearing it all apart.
Can I maybe ask the question this way, unless you got a direct follow-up?
Try one more time.
Yeah.
Assume we really think West Virginia means that if you required 100% gas, that it's unlawful. What's the distinction in terms of that we could draw in interpreting the statute between what you've done here and that?
Well, you could say that 40% is, not 100% and 40, you've got, at a minimum, you've got, as you've recognized, you've got almost half of the regulated fleet with access to natural gas. So you could uphold it for at least that subcategory as, not changing those plants in any meaningful way.
There may be a distinction between 40% and 100%. I don't want to just lose sight of that, but there may not be also. But I'm wondering if we think the following is true, that it would violate, let me put it this way. There's one way you could draw a distinction with West Virginia is to say that that's about grid level, and this is about plant level or source level, whichever the right term would be. So, but then that would mean that at the individual plant level, that it wouldn't be a West Virginia problem if what the agency said is, each coal plant needs to stop being a coal plant and become a gas plant. And then in theory, you could say, well, that's not grid level, that's source level, even though it tells each coal plant that it needs to shut down as a coal plant and open as a gas plant. Is there a difference between that and saying, no, we're not saying that. What we're saying is you need to co-fire gas at 100%.
I mean, this gets back to what are these plants? And
Yeah.
fundamentally, we think these are steam plants that are readily configured to burn different types of fuel. We're talking about, installing some gas lines, changing some air ducts, and putting in gas burners. These aren't major modifications. They're very minor.
So what I'm trying to ask is, would that equally be true no matter what the percentage level is? If you
Potentially, yeah. I mean, it's a record-specific analysis.
I'm just trying to get my mind around what the kind of the physical parameters of this are. So if the ratio were 90% instead of 40% of the co-fire gas requirement, then it could still be true that you're talking about the kind of modest adjustments that you have in mind. I know it's record-specific and you'd have to look on the ground at exactly what's going on, but that's still possible.
Right. The hypothetical I gave you was, what if you didn't have to do anything at all but switch the fuel? So there's no cost, there are no modifications. We would say totally fine to require the fuel to be switched.
Is that a realistic hypothetical in the world? That if the requirement was you need to switch the fuels altogether?
It's probably not a realistic one. I was just offering it as an extreme hypothetical.
Yeah.
But the point we're making is that what is being asked of the fleet here is not excessive. It's really, I don't think the Supreme Court was looking at how steam plants were configured deeply when it crafted that footnote. It may well have been thinking of transition to like a combustion gas plant, which is a very different type of plant.
And none of this deals with the fact that it's only in the medium category. That's just kind of a separate issue. But just within this, if we just assume that went away, you think there is a difference between saying 100% co-fire requirement versus shut down as a coal plant and reopen as a gas plant?
Yeah, I mean, again, if you're tearing down an entire facility and rebuilding it, that's a wholly different thing. But that's not what we're talking about. We're talking about going from a steam plant to a steam plant.
Mr. Hasso, can I ask you a question about remedies? If the court were to find parts of the rule invalid or unlawful or unreasonable, could they be severed from the rule as a whole, or is this a comprehensive scheme where the entire rule would have to be set aside?
No, we think that the components are severable, and there is a severability discussion in the preamble. So if you upheld, for example, one subcategory, that would be acceptable. You could just
And you
reject.
think we have that authority to set it aside in part?
We think you do, yes.
Is Mr. Myers going to talk about federalism? So should we, or?
It is. I'm also happy to answer any questions about federalism you may have before I wind up. But if there are no further questions, let me just conclude by saying this rule, in our view, accomplishes precisely what Congress intended. It addresses the climate change threats by properly establishing the degree of emission limitation that can be achieved by these plants through the best system of emission reduction. So we ask you to uphold the rule.
Thank you, counsel. Mr. Myers.
May it please the court, Michael Myers on behalf of state and municipal interveners. I'm going to focus on federalism. I'm happy to answer the court's questions in any other areas. I would like to quickly follow up on Judge Garcia's question a bit ago on operational reliability. Just had a few additional cites to the record to point you to, Judge, on this question as to whether or not EPA adequately considered operational reliability. First is at the response to comments, JA 5306 through 07, where EPA cites to a National Renewable Energy Laboratory study finding that grids can maintain reliable operation with increased use of wind and solar. And then JA 5536, where the agency cited to an electric cooperatives resource plan that was filed with the Colorado Public Utilities Commission. And that filing showed that that co-op could meet a high standard of reliability, even at extreme weather events, with a proposed resource mix that includes retiring coal units and adding battery storage. And finally, the grid experts amicus brief has a very good discussion of operational reliability and the portfolio approach that Mr. Hostetler was describing. That's on pages 11 to 14. Moving now to federalism. I'd like to start by talking about the respective roles of EPA in the states under Section 111D, and then touch on some specific issues about the presumptive standards and remaining useful life.
Can you just first speak to the question of whether we can consider these issues here or whether it's more appropriate to consider them in the separate litigation about the implementing regulations?
Yes, Your Honor. So the petitioners, or the state petitioners here, are making a separate challenge to the rule in which EPA promulgated this fundamental differences language, which is the main thing that they take issue with. So we think that issue should be decided in that case. The court has scheduled oral argument for next month in that case, so the cases are roughly aligned in terms of when they're likely to be decided. Petitioners do make a specific argument that does concern the rule in this case and remaining useful life. So we think, and that concerns the medium-term subcategory for coal plants. So we think that's an issue that can be and should be decided in this case, but the other issues should be left for case 24-1009.
But you do think that that sort of as-applied challenge, as Mr. Williams said, could be considered here?
Yes, Your Honor. Let me just go to that very quickly. So the petitioners basically say that EPA has removed the ability of states to consider remaining useful life with respect to that subcategory of the medium-term coal-fired power plants. And I'd like to point to the court to a JA say where EPA acknowledged that states could consider remaining useful life for that particular subcategory. So that's at JA 4983 through 84. And EPA acknowledged a specific example that a coal plant that would have difficulty obtaining natural gas to co-fire, but which intends to retire in 2035, could be eligible for remaining useful life could be eligible for a less stringent standard based on its remaining useful life. So that argument as to the specifics of this rule is meritless. Turning to the respective roles, and this is sort of taking a step back and a bigger picture question in terms of federalism. Section 111D really embodies the idea of cooperative federalism. And that means there are important roles both for the states and for EPA. And petitioners advocate for a pre-1970 version of the Clean Air Act, under which states get to call all the shots and EPA has like a weak advisory role. But that view is belied by both the statutory text and also the discussion of that text in the West Virginia case. Now, beginning with the text, the relevant statutory provisions show that Congress struck a balance between the states and EPA in regulating existing source pollution. Under Section 111A1, states establish the standards for individual sources, but those are based on EPA's determination of the best system of emission reduction and the pollution reductions achievable by applying that system. And then under Section 111D1B, states are authorized to take into consideration remaining useful life and other factors in setting standards for individual sources, but Section 111D2A charges EPA with the important role of reviewing state plans to ensure that they're satisfactory in limiting pollution. So as with other areas of the Clean Air Act, Section 111D, EPA sets a baseline of emission reduction, and states have some flexibility in terms of how to achieve those reductions.
Even if EPA has the ability to set presumptive standards, I mean, here the rule, makes a rule off sort of determination. And that determination, along with other factors, is specifically left to the states. And so now for a state to prove that their plan is satisfactory, they have to show that there's some fundamental difference between what they're proposing and what the rule proposed. I mean, doesn't that take too much away from the states? I mean, yeah, this is cooperative federalism, but this rule specifically takes off the table factors that Congress seemed to leave to the states.
Well, I don't think it takes it off the table, Your Honor, and I guess a couple of responses to that. First of all, states have always had to, under EPA's implementing regulations since 1975, had to explain if they were going to deviate from whatever the emission guideline was, what the basis for that was, be it, cost of control due to age of the plant or the design of the plant or physical impossibility. Those have been in EPA's regulations since 1975. So the fundamental differences language is really just a different way of saying this is how states have to make that demonstration. But they still can make that demonstration. And EPA made that clear in the rule. The second thing I would say in terms of the presumptive standards is I would point Your Honor to JA 258, which is subsection 60.5775BE of the rule, where EPA lays out 4 different options that states can follow if they don't want to do the presumptive standards. So those include rate-based emissions averaging across multiple units with the same owner, and annual tonnage limits for individual units or for multiple units to facilitate emissions trading. So states have options here, Your Honor. I see my time has expired. If I can just quickly conclude. The rule respects and reflects the careful balance that Congress struck in Section 111D between the states and EPA. And it will deliver critical greenhouse gas emission reductions to address harms in our states and cities, and do so while maintaining reliability of the grid. We urge you to deny the petitions for review. Thank you.
Thank you, counsel. Mr. Williams, we'll give you 2 minutes for a rebuttal.
Thank you, Your Honors. What we just heard was that a market shift was not intended from this rule, but I think it's important to step back and recognize what actually is happening here. The end result of this rule is that most coal plants will close by 2032. The remainder, after spending an interstitial period operating as hybrid natural gas plants, will then close by 2039. That is exactly the same result as the Clean Power Plan. And that's exactly the same thing that caused a major questions difficulty in West Virginia v. EPA. West Virginia said the question is whether the basic and consequential trade-offs involved in the agency's choice are ones that Congress would have likely intended for itself. Shifting generation, closing coal plants, forcing them to become businesses that are fundamentally different than the businesses that they are today are exactly the sort of fundamental and consequential basic trade-offs that Congress would have intended for itself. I also think it's important to recognize that if there are specific pieces of this rule that fall, whereas others somehow stand, we obviously don't view that as the case, but if the court were to view that being so, CCS really drives the boat here. And these provisions really are bound up in each other. So they cannot be severed from one another. And a sort of basic terse severability provision isn't enough to save this rule. We saw that in Ohio v. EPA, where the court said the agency doesn't just get to waive a severability provision and save its problems. It really is the case that if there are parts of this rule that fall, the whole thing has to go back. They have to try again. Lastly, on the issue of state discretion.
So you think we would have to send the whole, if we found some part of the rule either unlawful or unreasonable, we'd have to vacate the whole rule?
I think that is the case,
It
Your
would
Honor.
be because they're interrelated?
I think that's the case, Your Honor, particularly because there's sort of this nesting of different alternatives. And if one of the alternatives is in fact not available, I think it's not at all clear that the agency would have made the same choice and issued the same rule without that provision being a part of it. And that's ultimately what the severability standard is. I also think it's important to recognize the state discretion issue is in some ways bound up with that first issue of those alternative choices. EPA often defaults back to rule off and state discretion, the ability of states to make adjustments if there are points of tension that result from those alternatives. But if you really look at what they've offered us, we have so little room to maneuver that discretion, that room really is entirely illusory. And it reemphasizes sort of the wholesale, universal, problematic nature of this rule as a whole. So with that, petitioners would simply ask that the court overturn this rule, send it back to EPA, and respect the congressionally imposed limits that the Clean Air Act recognizes. Thank you.
Thank you, counsel. Thank you to all the counsel on this set of issues and to all counsel on all issues. We'll take this case under submission.
Honorable court now stands adjourned until Monday, December 9th at 5:30 p.m.